could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes, yes, yes. Yes, you already know what we will do. If we unite, we will shut shit down. Blessings, blessings, y'all. I'm not going to be coming on the screen tonight. Okay. We do have a live set up for you tomorrow. We're going to have a great time. But tonight, I wanted to make the family aware, or we're aware of what's going on in Georgia. There's more significant cases going on. And this is one of the cases where 3 Georgia men was tried and charged with murdering Ahmaud Arbery. Okay. And this happened in 2020. So at this time, these gentlemen are seeking a new trial. So we do have the footage. It's going to be a pretty eventful night, pretty long. But if you are here for it, I'm here for it. But before we get into that case, I just want to give you guys a flashback of another case. This actual case took place in New York. Now, before we talk about this case, you see what we have at the bottom of the screen. God, people win in the end. And that's what I believe. I really think that it is a war against good and evil, because as you're going to see, it goes across color lines. And I know in this particular story is 2 Caucasian men who have done something to consider African American men. But when I see these 2 stories and I review them, I think of dementedness. I think of evil. So that's why I had that, because this is across color lines and we have seen this happen so many times. Now, this is not even including the police. This is literally people against each other. Do I think there is a racial charge to it? Yes, I do think so. I do think that is a disregard for brown melanated people. And this is a subconscious thing for some people, and some things is not. And this is something that has been embedded in our culture. And this is something that we have to learn to eradicate by realizing the foundation of some of this stuff that we see is demented. Okay. Is war against good and evil, and you're going to have a pick a side. So in this particular case, I'm going to put up this is a 5-minute video of this gentleman. Did you remember the subway unaliving of the gentleman who actually hold Mr. Jordan in a chokehold? So we're right now, this guy, he's been locked up for a little while. He is going to trial. So that's something that we're going to be bringing to your attention. But we're going to do a quick flashback real quick. This is on my other page. I'll leave the information down there for you. I was told it's better not to say the page's name, but as you see what it is, okay, you know, always got backup. So this was something I did a while ago, a year ago. So let's play this. Let me see.
You are gifted. It's okay to be soft.
Oh, long intro, y'all. Wait a minute. Wow. Wait a minute. We got another update for you guys. And this is the Michael Jackson look-alike killer. I'm just going to call him that. You know, the young man who was murdered on the train. You know, I got mad about that because when I watched the video and I'm like, all of these people watch this young man be choked on a train. And like I said, everybody there had mental illness. This guy is in the military. And they first wasn't pressing no charges until we got outrageous, because this is murder, and that's what he did. So grand jury indicts Daniel Penny in the death of Jaden Nilly. So this is Mr. Michael Jackson, according to the ABC News. I'm sorry I call him that, but you know he's a Michael Jackson lookalike dancer. ABC News, a grand jury has indicted former USA Marine. Okay. For the death of Jordan Nilly. If you call Daniel had held Jordan in the chokehold according to the subway train, which resulted in his death. Jordan's death was ruled a homicide. per sources, Daniel expect charges will not be unsealed until he appeared in court later. Daniel was initially arrested on second-degree manslaughter charge. Now, the reason why he definitely should be charged, as I told you guys, because once you're trained in certain skills of combat, you are a weapon. You should be certified. My son is a second degree black belt. It is what it is. He's a walking weapon. You got to be taught how to stay calm, cool, collective, not to react, and they know their point of trigger. They know what will lead to death. They've been taught this. So this man deserves what he got. So it's rule of homicide, man involved in a subway encounter, killed in the chokehold, death ruling. Okay, so this is the press release by the lawyer. I'm not even going to read it. I'm not going to read it. Look at his face. This is when he was doing it. So let me stop right here. I kind of looked at myself in old videos and I kind of chuckle at myself, just talking mess, but I kind of try to keep it as light as possible because these things are very tragic. So basically, right now, he is about to go to trial, and we're going to keep you up to date on that. I don't believe that they're allowing us to um, for it to be recorded, but they are keeping their eye on it. Hopefully, they open up the court. So let's just play this real quick. Music. Okay, so the jury selection has started in the death of Jordan Neely after the confrontation on the New York City subway in May 2023. Now, I do have the video. Penny 25 is accused of recklessly causing the unaliving of Neely at 30 years old, former street performer, by placing him in a deadly chokehold after Neely allegedly attacked erratically. It went fast. The trial takes place in Manhattan and is expected to last 6 weeks and has resonated confrontation on race, public safety, and mental health. Yes, conversations. That's what we're doing. Neely, who was black, had a history of mental. Excuse me. Just a little. I'm sorry. It's going a little bit fast. Or maybe I'm reading slow. All right. So Neely, who was black, had a history of homelessness, drug addiction, and mental illness. Put that in red. Meanwhile, Penny, who is Caucasian, who it says white, Caucasian, found himself backed by supporters, including some political figures, once charges was filed. So basically, this is very controversial. I'm just going to tell you that at this particular time. So this is, I'm sorry, I don't know what this is. There's another case that we're going to be paying attention to. I'll put the picture of it for you guys to pay attention. They are at jury selection. So hopefully if they let us into the case, we'll keep our eye on what would be his defense. And as I mentioned, you know, when you have training like this, especially even when it comes to the cops with the it was Sonia Macy, who just passed away. It's training. You're supposed to be trained in your skill. And as a Marine, I think that's who this guy was. I don't think that he should get any leeway. So anyway, we're going to keep you up to date on that. That's just something I want to bring your attention. Hopefully we can bring you an update this Saturday. And hopefully they have some good clips or something inside the court, because that's what I like to see. Now let's get to the Ahmaud Arbery. Okay, so the Ahmaud Arbery case, I'm going to put them on the screen with these three gentlemen. We're just going to do a quick flashback. And hold on, let me make sure I'm looking at the right article. Okay, yeah, we're just going to do a quick flashback. This happened in 2021. Again, like I said, there is a color issue. It is dealt with race. I do believe that, but I do believe that this is demonic, because you have to have no heart. You have to have no soul to go about doing some of these things. So let's do a little flashback. The Ahmaud Arbery defendants was convicted of felony murder, a charge that has drawn scrutiny. Now, I have the video, and we're going to watch. You want to watch the video? We could watch the video before we watch the trial, because I don't know if they're going to show that. But I think showing the video will make you guys recall kind of how horrendous this was. So of the three men found guilty of the unaliving of Ahmaud Arbery, two was convicted under Georgia felony murder law, which allows for people to be charged with murder even if they did not directly kill anyone. And that was, some of the individuals that was on the sideline chasing and blocking him off. Okay, statutes like that one in Georgia, which carries a mandatory life sentence, have been denounced by some states by some critics who says that they can lead to overly harsh punishment for accomplice to being a murder. So it's like that's their argument. I think regardless of this case, I do think that's pretty harsh because I know Florida has a case that's a law pretty harsh as well, like that, where if you are in the commission of a crime, and I definitely know it's Florida and other states have picked this up, and the person you're doing a crime with your partner gets unalived by police or the situation, you as being the co-defendant will be charged with murder. And I know this from personally knowing people who went through this, which is very horrendous. So I do agree with the critics on that particular part as far as a life sentence. But at the end of the day, in this particular sentence, this was second degree murder on all of their parts. They intentionally did what they did, in my opinion. You let me know what you think as far as first degree, second degree, and in that case. So statutes like this has been criticized. Let's see, in the unaliving of Arbery, only Travis McMichael, who fatally shot Mr. Arbery, was convicted of malice murder, meaning jurors found that he intended to unalive Mr. Arbery. The other two defendants, Travis McMichael, father, Gregory McMichael, and William Bryan, the neighbor, were convicted of felony murder. Means juries concluded that the men caused Mr. Arbery death while committing another felony. Okay, so that's kind of like a flashback, and this is where we're at right now. The three men are found guilty of murder of Arbery. Okay, so this was in 2021. After that,
verdict is as follows. In the Superior Court of Glenn County, state of Georgia, the state of Georgia versus Travis McMichael, case number CR 000433. Jury verdict form. Count 1, malice murder. We, the jury, find the defendant, Travis McMichael, guilty. I'm going to ask that whoever just made an outburst be removed from the court, please. Count 2, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 3, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 4, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 5, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 6, aggravated assault. We, the jury, find the defendant, Travis McMichael, guilty. Count 7, aggravated assault. We, the jury, find the defendant, Travis McMichael, guilty.
I'm gonna have to stop it right there because it is really heart wrenching to me. So you heard the gunshot, you saw what was going on. He was just literally jogging and trying to get away from them, just stay away from them. So we're going to now get into the actual court case that's taking place. Thank you for being here with us tonight. Shout out to YouTube, shout out to Rumble, because we're streaming on both. Hit the like button and remember that we're here to communicate and talk about it. So, what's this? This is a little clip. Let's see what this little clip is, real quick.
Ahmaud Arbery in 2020 are returning to court today to ask a judge for a new trial. A judge is going to hear the legal motions for 2 days, and attorneys for Arbery's killers, Greg McMichael, his son Travis McMichael, and their former neighbor William Bryan, are making a range of arguments for a new trial, including claims of a tainted jury and claims of ineffective counsel for one of the men. In February of 2020, 25-year-old Ahmaud Arbery was jogging in a Glenn County suburb when the McMichaels and Bryan followed Arbery, pulling their truck up next to him, ultimately shooting and killing him.
Right. So you see,
don't bring your dog.
You see what their arguments are, according to the news, but we're going to listen to it because I think this is going to be very interesting to hear their angle, and then start to follow this and see what the state is going to come back with. All right. So let's get it on the screen. Thank you for being here with GracLevi. When I saw this morning, I was like, dang it, I missed it. So I said, we're going to play it again. We do the recap and we get uncensored. So let's go. Make sure.
Lee Wilson.
Turn your mic up. Hold on.
It's designed not to find out what the trial teams had actually done, but to procure evidence in a state's position in a legal attempt to violate Rule 606 verdict. So the state has a deep concern about how these interviews were conducted and how this testimony was elicited.
Now, just let me know, can y'all hear? Because it sounds really low. So I'm going to try to keep my mic open so y'all can hear it. Let me know if you can't hear it, okay?
And the basis for our objection is actually the United States Supreme Court. The United States Supreme Court has basically held that the substance of Rule 606, which has not changed since 1975 when it was enacted, with one exception in 2006 where it modified permitting evidence for the clerical mistake on the verdict form. Our Rule 606, which was enacted in our new evidence code in 2013, is identical to that particular 2006 Rule 606 federally. But in 2017, in Pena Rodriguez versus Colorado, the United States Supreme Court held that Rule 606 promotes full and vigorous discussion by the jurors while deliberating because it provides jurors with considerable assurance that after being discharged, they will not be summoned to recount their deliberations and they will not be otherwise harassed or annoyed by litigants seeking to challenge the verdict. Rule 606 gives stability and finality to verdicts. And the Supreme Court of the United States in 2017 was relying on their own opinion in the Tanner case, Tanner. And the Supreme Court echoed the concerns that if attorneys could use juror testimony to attack verdicts, jurors would be harassed and beset by defeated parties, thus destroying all frankness and freedom of discussion and conference in deliberations in the jury room. The Supreme Court of the United States was concerned, moreover, that attempts to impeach a verdict would disrupt the finality of the process and undermine both jurors' willingness to return an unpopular verdict and the community's trust in the system that relies on the decisions of lay people who are our jurors. The United States Supreme Court did actually go on to determine and elucidate that there are existing significant safeguards for a defendant's right to an impartial and competent jury beyond any sort of post-trial juror testimony. They noted that at the outset of the trial process, there's voir dire, which provides an opportunity for the court and counsel to examine the members for their impartiality and any biases. As the court is aware, jury selection in this case was longer than the state presentation of the evidence and the defendant's presentation of their evidence. We did a thorough job with voir dire, doing individual sequestered voir dire, and that is one of the safeguards. The Supreme Court of the United States noticed that as the trial proceeds, the court, counsel, and court personnel also have an opportunity to learn of any juror misconduct. That is because bailiffs are available, and they are allowed to note if they witness any juror misconduct. And before the verdict, jurors themselves can report misconduct to the court. And as this court is well aware, this court instructed the jurors both in the morning and every evening that they were not to discuss this case with anyone, not even amongst themselves, and they were to report back to this court via the bailiffs or the sheriff's department any irregularity, any outside influences, anyone who attempted to approach them, and this court vigorously instructed them on this. The Supreme Court of the United States held that these procedures do not undermine the stability of a verdict once rendered, and even after the trial, evidence of misconduct other than juror testimony can be used to attempt to impeach the verdict. I want to note here, other than juror testimony, extrinsic evidence must be what is presented. I provided the court and defense counsel with two cases from the 11th Circuit, United States versus Cuthel, C-U-T-H-E-L. And that went over the court's duty to investigate. And that only arises when the party alleging misconduct makes an adequate showing of extrinsic influence to overcome the presumption of jury impartiality. Actually quoting to United States versus Sun Mun Yoon, and that's that 1983 case where they were accused of tax evasion, that a trial court is required to hold a post-trial hearing only when reasonable grounds for investigation exist, when there is clear, strong, substantial, and incontrovertible evidence. And the state's position is that we do not have that here. In other words, a specific non-speculative impropriety has occurred which could have prejudiced the trial of the defendants. That is what they're required to show, non-speculative impropriety. A hearing is not held to afford a convicted defendant the opportunity to conduct a fishing expedition. That is right from the United States Supreme Court in the 1983 decision. Of course, relying on our Rule 606, the defense attorneys did provide this court and myself with the transcripts of the three jurors' statements. Everything within those statements, they do not rise to the level that the Supreme Court of the United States requires and the 11th Circuit requires, which is specificity from an external source other than going back and interviewing jurors 6 or 7 months after they have rendered a verdict. And with 606, we have 3 prongs. One does not apply here, and that is filling out the verdict form incorrectly. We have the first prong, which is when a juror seeks out extraneous prejudicial information. As you will recall from one of the cases, they had a juror, it was a habeas case out of our Supreme Court here in Georgia, who actually did a test drive to go ahead and determine whether the defendant could have made it to the crime scene on time. Of course, that is a juror seeking extraneous prejudicial information. The other example, which is the Part B under 606, the second prong, is if a juror has someone who tries to bribe them or tries to threaten them. It's an external pressure on that juror, not something made up in the juror's head. Okay, and I would analogize that to defendants who are being questioned by the police who think, well, I thought they were threatening me, or I thought there was hope of benefit, but it was all made up in their head. The police did absolutely nothing to encourage that. In this particular instance, there's absolutely nothing where there has been shown that external influences were brought to bear inappropriately on any of these jurors. So the state's position is that we're objecting under Rule 606 and under the cases I've cited because nothing that they have provided to us so far from the jurors' own words rise to this level. And there's been absolutely nothing provided to the state that they're going to provide extraneous testimony through a witness or documents or anything else that these jurors were appropriately influenced or pursued extraneous information, or that extraneous information was given to them. Thank you, Judge.
Yes, Your Honor. I noted first, with respect to the, Ms. Donikowski's recitations of federal cases does not take into consideration the decision in Harris versus State, 2023 decision. I thought I had it right there. I'll bring it later to the court's attention, but in which, among other things, the Supreme Court of Georgia noted that there are differences in the application of Rule 606 as applied to state courts, or the state application of it as applied to the federal application of it. In fact, jurors are from time to time subpoenaed to testify regarding exceptions under the rule. As stated in Official Code of Georgia, Section 24.606B. There is a prohibition in the first part of that, which is absolutely a prohibition against attempting to impeach a verdict, which the court has received from us a notice of our intent that included exhibits from the recorded interviews of the 3 jurors who did speak with us. And note, it's a bit of an overstatement to say all 12 of them or 9 of them refused to talk to us. A few did, and some were just not available. We couldn't find them. But 3 did talk to us. And we submit, and we have submitted to the court, which in a somewhat awkward situation where our understanding was that some things that we submitted to the court were not to be filed with the clerk of court. And well, I wanted to read the court's order, Your Honor. And if, I want to make very clear for the record that no time during this proceedings, and I think the history of this proceeding are very clear, that this court ever instructed anyone not to file something or do anything that would require a sealing or other action by. I understand that notice may have been misread. That's not a concern of the court. I understand the state was served with everything, the court received everything, so I don't intend to debate it. But I just want to make sure that we're clear on the record. This court has never instructed anyone not to file something. If I might address the court with respect to the language of the court's order. You don't need to. I'm telling you, the order was never intended to tell anyone not to file something. We have submitted to the judge, to Your Honor, and to opposing counsel and to co-counsel all of the material that we're addressing. We prepared and submitted to all parties the notice of intent to present juror testimony. Attached to that notice were exhibits that described in part the testimony. I'll call it a pre-proffer. We wanted to alert the court and alert counsel what it is that we are attempting to present to the court. I misread perhaps the court's order as saying that we should submit those things to the court, to the judge, and to counsel, but not file it with the clerk, which what I did was file the notice without the exhibits, and I'll cure that today by filing the exhibits put them on the record. And I understood it to be a matter of this court's concern over the anonymity and privacy of these jurors. The court went to great lengths to preserve their anonymity and to preserve their privacy. And it is very important that they be protected in that way, because it's a high-profile case. There were demonstrators, there were reasons to protect their anonymity. We read the court's order as saying that, and in fact, I addressed the court in correspondence asking for direction on that. I addressed the court in May, I addressed the court in September twice, and within our notice asking the court to direct us as to how do we go about preserving the anonymity of the jurors. Seems to me that it was a very important factor to this court, and we did not want to run afoul of the court's order. Had we filed the exhibits, then we would have been disclosing the identity of the jurors, and that's the reason we sought direction. Let me get some water. I had an accident, Your Honor, in September that for the time being limits my mobility. So I'm having to use a walker and a cane. And I get very dry mouth. Addressing Ms. Donikowski's argument, State v. Harris notes, and that's the 2022 iteration, and then again in 2023, our Supreme Court has held that the application of 606 is different under the state rule as opposed to the federal rule. Ms. Donikowski has cited to the court 2 federal cases. Even then, the rule, second part of the rule, after we go through the first sentence or the first clause, prohibits juror testimony that would be what is generally known as impeaching the verdict. We're not attempting to impeach the verdict. The second part of the rule provides a juror may testify on the question of whether extraneous prejudicial information was improperly brought to the juror's attention, whether any outside influence was improperly brought to bear on any juror. And then the third one has to do with the verdict having been improperly filled out. We're not addressing that third one. In our proffer, I submit that the juror testimony that we have offered in connection with our notice to the court is exactly what is permitted under the rule, and that is whether extraneous prejudicial information was improperly brought to the juror's attention and whether any outside influence was improperly brought to bear on any juror. I don't know, even today as I stand before Your Honor, how far to go with the gallery here, how far to go in discussing that before the court without going into the specifics of individual jurors and without going into their identity. And I still seek direction on that. We're prepared to go in any manner that the court directs, but I don't know what the court directs on it. I've been doing this for over 50 years. I've had a few motions for new trial. I've had jurors testify, but I've never had a situation where I needed to preserve the anonymity of jurors, and that's where I need some direction. That's the position, is that what we have submitted to the court, what the court has before it, what the clerk does not have before it, is material that we submit fits the exceptions under 606. Now, am I at liberty to discuss that exception now, to talk about what these jurors said, or does the court want to continue to preserve some sort of anonymity?
Then I'm sorry.
So I think everybody generally in the same zip code here with 606. But when we, well, and my understanding maybe a second issue out there, which really brought up this point, had to do with answers on the one hour.
That's correct, Your Honor.
But there has to be some, I need to know what it is that specifically under Rule 606 that we're considering Rule 606 that the defense intends to present that would be relevant and material to the motion for new trial.
If I might refer to the notice that we gave to the court for a moment. I am prone to falling and can't get up when I do. This is from the notice that we presented to the court. The notice was filed without the exhibits on October 7th of this month, October of this month. I had in earlier filings with, not with the court, but in exchanges with the state, had certainly not withheld this information. The court, the state would have known what we were doing. The attachment, the first is an Exhibit A, which is the affidavit by the investigator who conducted the interviews. And there were several issues involved in these discussions. And we'll just go by number and in sequence. Juror number 79. At page 8 of that interview recorded, and the court has the transcript. When I say the court, I need to distinguish between Your Honor and the court in some way. The clerk of court does not have this. Yes, Your Honor. That's that was submitted to the judge and to the parties, not to now the covering notice was sent to the clerk and has been filed, but we did not, and we specifically noted that we were not attaching the exhibits to the notice as filed.
So maybe this will shorten this up. So the profit that you intend to make would be these jurors' statements. So literally are limited juror statements contained in this notice of intent?
No, Your Honor, it's broader than that. This was just an excerpts from those recorded interviews that we believe fit the exceptions under 606. And with the entire interviews, one is 80-some pages. That's for juror 580, juror 380, and juror 79 are shorter. I think one is 41 pages and the other is 50-some odd pages. But we have those here in a form that we mark them as exhibits, the entire interview, and intend to proffer them to the court, at least to make a proper record as to what the substance of that was. What you had in the way of exhibits to the notice was excerpts which we felt illustrated that the jurors, and of course it's hearsay as long as we don't have these people here to testify. That's the reason we subpoenaed them. What we have is what the affidavit from the investigator is not offered for the proof, to prove the truth of what these jurors said to him, is offered and not as hearsay, because it is simply testimony or an affidavit to the effect that this is what the jurors told him, not that this is true. Now, in order to deal with the truth of it, we would have to have the jurors here to testify. And that's why we subpoenaed them.
I'm just trying to figure out what we need to work through, because there's a legal issue on Rule 606.
Yes, Your Honor.
Let's stick with it. Mr. Chapman, Mr. Zeller, are you going to be adding anything on the legal side of this, or are we really getting into the problem? No, Your Honor, nothing on the legal side.
No, I think we all agree with the law. Is the question is whether or not the proffer is to stand.
Yeah.
That's it. And it's just whether or not the council is going to stand.
So let me set the stage then for whatever this proffer is going to be. So I did look at the notice of intent.
Yes, Your Honor.
As the excerpts from these. And let me, I guess I'll try to present the guardrails that I see and then see where this proffer is. There's two issues as I understand. One is there was a juror who apparently appeared at the courthouse on the weekend. Well, really, there's 3 things raised. Yeah, the juror who appeared on the weekend, this one issue. Question of whether or not a juror held a bias that was undiscovered in voir dire. And then finally, there are a number of statements in here from a couple of these jurors about what they thought of the charge. Okay.
Yes, Your Honor, that much is submitted because part of our motion is that we contend that the court erroneously charged the juror with respect to the law of citizen's arrest. And that's something that I assume that you and I will continue to disagree about, and which is what we do, lawyers and judges.
Sometimes.
Well, I've had, one of the things I wanted to do, and the sheriff said I had to get your permission, is I wanted to record this proceedings because I've been at it a very long time and I've had one motion for new trial granted. Judges like to say if there's an issue, they like it to go up because of if you grant the motion, there may be some finality. And I fully understand that this court, at least statistically, the odds are that this motion will not be granted. But my job then is to create a record that we can appeal on. And that's an appropriate approach for a judge, because if you were to reverse your various rulings in the court, then we'd have some chaos as to where we are, and we'd be granting a new trial, and the Supreme Court needs to pass on these. And I understand that will be. I'd be surprised if that is not the court's attitude. And the reason I wanted to record these proceedings is because I hope to continue to represent Travis McMichael in an appeal to the Supreme Court. And I wanted to record and create my own transcript and get ahead of the game so that I can begin working on that. That request is before the court. I did not bring the recording information here today because my assistant, who would be here and will be here, is not available this morning. So that's just asking the court. That's kind of off topic. The proffer, and I'd call it a pre-proffer, is with this notice of intent, is to submit to the court, this is what we hope to proffer to the court. and it just is excerpts from the transcripts. And the transcripts have not been authenticated beyond this affidavit. And as Ms. Donikowski has correctly noted, that this is hearsay, but has not correctly. She has said it's hearsay, and it would be hearsay if we were submitting it under Rule 801 to prove that these jurors told us the truth. It's just an affidavit to establish not that it's truthful, but that this is what the jurors told us. And then they would have to come and verify or deny that they said these things. And that's when the actual evidence would be. What I brought is transcripts, the full transcripts marked as exhibits, which I certainly don't want to read to the court. There's hundreds of pages, but Mr. Wilson, the investigator, has compared them to his audio tapes and will testify that they are correct and accurate statements of what was in the audio tape. Now, one of the jurors said, well, I was just going to get back to sure.
So we've got these three issues. First, let me address the easy one first. As to any juror statements about the jury charge, that's not covered. Whatever the jury thought of the jury charge, their impressions of the jury charge, all of that gets directly into the deliberations of the panel, which is clearly not permitted under Rule 606. So that is not covered.
We respectfully disagree and understand that the court overrules any objection we have on that. Our position on that is not what they deliberated, is how they interpreted the written charge. And one of the jurors even talked about on the rule of pertaining to citizens' arrest, that we applied the new law and not the old law. Well, there is no new law. The old law was just repealed, and we had to do it according to the letter of the law. So that we.
The issue that goes directly into jury deliberation, they would not have received a written charge until they were in deliberations.
That's correct.
Which then just further confirms to the court that concerns the deliberations of the panel. The next issue.
Well, respectfully, when we tender the recorded interviews, we will tender the entire interview and respectfully submit that it is appropriate and not fault.
You can create your record.
That's all I'm doing here, Your Honor, and I think I've indicated that's all I expect to accomplish today.
The second issue is the juror that is alleged to have appeared at the courthouse during the weekend. I think Rule 606 makes very clear that it would be permissible to determine whether or not that juror was provided any extraneous information. But that's where the inquiry stops. Other than whether that extraneous information, I guess, was actually provided to any other juror. What the impact of that extraneous information was, if it existed, and how it was addressed by the panel individually, I mean subjectively, is not an area that we're going to get into. The argument then, from the court's perspective, is if there was any extraneous information, whether objectively that could have had any impact on the panel, if in fact it was shared. And that's going to be the limitation on the court's ruling.
Again, Your Honor, I understand the court's ruling. We respectfully disagree. The testimony that we're addressing in that particular instance is that this juror, during the demonstrations, after the court had instructed the jury to stay away from interaction or hearing or talking with you, he went. There was apparently a hot dog stand or food trucks or vendors out on the grounds around the courthouse, and he came down. His transcript says he came down, purchased a hot dog and listened to people who were making speeches of the nature that I suspect was justice for Ahmaud. But he described what they said was, in his words, blah, blah, blah. I mean, he didn't go into detail about it, but he was listening to people making speeches at the rally for Ahmaud. We can only assume that he was not hearing things that he was hearing things that he should not have been hearing, and that is an extraneous injection into his deliberation. The law is not, and I'm familiar with the cases the court's relying on pertaining to whether he shared it with others. But there's a presumption, and this is one of the places we disagree, or the Georgia rule Supreme Court has a different interpretation as to Rule 606 as opposed to the federal courts. If we show this is inappropriate, it's misconduct, and there is then a presumption of bias or prejudice or against, well, actually against the state. The state then has to prove beyond a reasonable doubt, not by a preponderance test, to show beyond a reasonable doubt that it did not impact did not impact this juror. That's the difference between the federal and the state application of 606, and that's in the Harris case. And then there's an additional argument with regard to that juror having to do with his responses in voir dire, and that's not the issue right now we're talking about, but I can bring it up.
Okay. It's the third issue that I'm about to address.
All right,
It's indicated where I am on the first two issues. As to the question of his answers, there are some questions and answers in this notice of intent, affidavit, however you want to describe it, indicating his personal position about certain things. The issue for the court is, as I understand it, whether there was a material falsehood that he presented a material falsehood during jury selection with regard to any bias, and whether or not that material falsehood resulted in prejudice. That is what we're going to limit any inquiry to, whether or not there was a material falsehood during jury selection. Now that's, we'll just candidly say you're going to have to get into a very, I assume this has been done, and he gave extensive answers during jury selection, which are in the transcript. So the issue isn't so much what he said, but whether or not what he said, as compared to what was going on during jury selection, indicates to the court that there was some material falsehood.
Respectfully, in the court, the state has honed in on his truthfulness in individual sequestered voir dire. Our issue is, or our point is, that it was false when he answered, along with all of the people on the panel, the general voir dire questions, not the individual voir dire questions, when he said there was no bias or prejudice resting on his mind. And that's where we address his falsehood. Because of the things, let me get the language. And in our amended motion, I addressed it at page 12. Juror 380 concealed his bias in favor of the Arbery family. And of course, to even get the individual sequestered voir dire, you have to pass the general voir dire, in which you declare that you have no bias resting on your mind. And I might read some of this to the court. My investigator asked, "What were your thoughts?" This is from the transcript, which I understand has not been authenticated or presented to the jury, but this is what we expect the transcript and the recording, and we have the recording, would say. "What were your thoughts when you were selected as a juror? To tell the truth, I felt sorry for the family, so I said, Lord, I feel sorry for the family. You want me to help them, then I don't mind helping. Don't mind doing it." Like that, just as I was talking to you. But when you say, this is the question, you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. Thank you, sir. I appreciate it. I'll go back. When you say you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. I didn't understand what you mean, felt sorry for the family, the investigator's question. And his answer was, I felt sorry for the family and everything. That was even before I see the tape, the film and everything. So I talked with the Lord, and this is a very religious man. I sat on his porch last week and talked with him. He's very faith-driven. So I talked with the Lord on the way, going to work. I said, if it's up for me to do this, then I'll do it to help the family. Justice got to be done. Then on the next page, when you say the family, you're talking about Mr. Arbery's family as far as what all they had gone through. Yeah. How much, if any, influence did all these high-profile people coming to this trial and obviously sitting in support of Mr. Arbery's mother, how much did that play in how you thought about the case? Because you acknowledge you felt sorry for the family, and who wouldn't? They lost their son. And Mr. 380 says, yeah. And then the question is, did that have an impact on you? Answer. Not really. At first, I feel, like I said, when I found out, this next sentence is one that kind of gives away who he is, but I'll go ahead and read it. When I found out I was the only black, I was like, oh my God, now I'm laying in bed, can't sleep anymore because I felt like the weight of the whole black race was on my shoulder. And I started praying. And the Lord said to me, he said, all you got to do is just what I tell you to do. And I'll coach you through the whole thing. He said, you got to talk with everybody. You can't be quiet because they'll think you're mad. Because, and he says, I never did get mad. I got a little angry when I saw the tape. And then further down. So the Lord, he set everything up. Anyway, after I cried for the family, and it turned to a joy cry, and didn't even know I had been picked for the jury yet. When he did not make these feelings known in response to the general voir dire question, have you formed and expressed any people.
So now we're making arguments. So what I was simply saying is the issue before the court is that you are alleging that there were material misrepresentations made in board doc.
Yes, Your Honor, there's some material misrepresentation in the form of not acknowledging his, because it's a general board doc question posed to the entire panel.
And let me remind everybody, because I know some folks did not participate in board doc, that board doc there was a two-step process to board doc. There were general questions that were agreed to by all counsel, and then based upon the general questions, each party was then given the opportunity to indicate to the court whether they wish to have the juror come to individual board doc. Juror 380, who we're talking about, went through individual board doc, which was then a process that allowed clarification by all lawyers, because all parties then would have an opportunity to ask that juror questions. And so that's why I have indicated a couple of times now, what I would expect if we go down this road with any of the jurors is that there is reference to that juror's answers to board doc. Because whatever he has said now is all well and good, but that's not what we're looking at. The issue before the court is whether there was a material misrepresentation during board doc, and ultimately that prejudiced the defendants. And so the ruling of the court is we're not just going to get into these statements. There has to be some reference for the court to the statements or positions, opinions, because all of these different things were presented during the board doc process. Because my understanding is these statements were provided months, 6 months, 8 months, 9 months.
No, Your Honor, the recording, the interview was roughly 6 months after the trial. The focus of this is what was this juror's attitude and bias when he did not, when he was asked, along with the rest of the panel, when he was asked if he had any prejudice or bias resting on his mind. Now,
I've indicated what the court is. There needs to be a record because there is an extensive transcript on juror 3.
Yes, Your Honor.
And General Bordier was followed up on by all the points. So I looked through it, not in the detail that I'm going to ultimately have to, but I know based on my preliminary review of juror 380, and that there were questions. Let's see, Mr. Rubin, on behalf of your client, did the individualized Bordier. He was asked about his opinions, whether he could put any of them, receive some pretty straightforward opinions. Specifically asked by Mr. Rubin, again, representing Travis McMichael at the time, whether or not he could put any of those issues aside and listen. So again, the court is going to need more than simply statements made 6 months after the verdict. The issue before the court is whether there were material misrepresentations made during court document.
and we respectfully submit that this portion of his transcript reflects that he got on the jury so that he could help the Arbery family. That and maybe stated too strongly in my motion, but we look at him as he was there to assure that there was no acquittal in this case. That's why he was there. That's what the Lord directed him to do. Now, I sense the court's ruling.
Well, you don't need to sense it. I have provided it.
All right, well, that said, we still stand on our position and take the position that this evidence, when it becomes evidence rather than a transcript which would now be hearsay, but once he testifies, it shows that he got on the jury by not disclosing that he had a bias in favor of the victim's family. And that it guided him so much that the Lord told him what to do. And we'll stand on our position. I secure the court's ruling, and I certainly understand the court can make a ruling. The question now for me is, what may I proffer to the court? And if the court, I would at least submit that our notice of intent to present jury testimony is an adequate proffer of that issue. We have to submit the exhibits to the affidavit, which we didn't because we were protecting juror anonymity. At the same time, I submit it's an issue that needs to be decided in Atlanta, and that's why we want to create a record here.
I understand where. Anything then from Greg McMichael? From Mr. Brown?
Are you asking on everything that?
What we've addressed? Well, let me ask you to be more specific, because I was going to go around the room to make sure everybody understood what the court's position was in ruling on the three matters that we've now discussed with regard to these jurors being called and what the court will allow for testimony. Any questions about that?
I did want clarification on position number 2. You allow for testimony on, I guess, the outside influence or the extraneous information, but not how it affected the deliberation.
Not how it affected his deliberation. Right. That's an objective inquiry for the court.
Right.
So, objective inquiry for the courts and objective, I guess the argument from the defense perspective, an objective argument on how that influenced or could influence the panel to the point where it would be impactful, given the understanding of the court's having that done.
So will we be able to show the type of influence that was around the court that day, or that during the trial?
The court's ruling is this juror is being called because it's my understanding that there's a belief that he received information extraneous to the court, right, from outside the court. I don't know that he did, based on what I've seen in the affidavits. I'm not sure specifically what that is, but I'm going to permit inquiry into whether or not there was anything extraneous there. Then we'll alternate whether he mentioned it to anybody else. But as far as whether he considered or how he considered that during deliberation, or what he thinks any impact of it would have been on deliberation, we're not going to get into it.
And just one follow-up, if I may. Also, with regard to 606, it says whether any outside influence was improperly brought to bear upon any juror. So would he be able to talk about the outside influence that he witnessed, or
Yes, that gets into deliberation.
okay?
I'm sorry, I didn't mean to interrupt.
Hold on a second. I think it's very clear on what was going on. I believe Mr. Goff, on behalf of Mr. Bryan, has made a very clear record as to what was going on around the courthouse during the trial of this case.
I was going to make, I have a list, right, so I don't need to do corruption. And I agree that it's not, the law is clear that jurors can't say how it happened in the deliberation. On the last issue, I think we talked about juror 380 and his misstatements on juror here. Is that correct? I will just add one thing that I do have in my notes, and this was really what was from my written juror transcript on page 2156. There was a notation from Mr. Jagall that the juror had nodded at the victim's family. The juror nodded at the victim's family after he was walking out. So that was something that was raised on, and that was volume 9, part 1. That was the notes I had. His individual started on page 2100, and then walking on 2086 is when Mr. House said, in my note, this is what I wrote down. He says that the juror nodded at the victim's family as he walked out, and he didn't ask for it. And later on, when the court asked for obstruction of cause, and that there was no motion to stop the cause. So they just wanted to point that out.
During Fort IRSL.
Yes.
At the end of individual animal. Yeah, I might have not, I can't remember whether there was a motion for cause.
There was not a motion for cause on 380. There was not. That was in the very next That was volume 9, part 2, motion for calls for those that can.
From the state, any question about the,
No, Your Honor.
Two points. One, I work very closely with Mr. Chappell, representing Greg McMichael. I represent Travis. My understanding is he adopts in full what we've argued here and what we presented in the motion.
yeah, we'll go over that.
And the argument I've made here today. Your Honor, I have heard and will certainly abide by the court's rulings. I must admit I'm not 100% certain where you are limiting me in terms of presentation.
I don't think I can be any more.
Well, am I going to be permitted to have my investigator come testify regarding the accuracy of these transcripts? I'm not going to ask the court to look at the transcripts or read the transcripts. There are hundreds of pages, but he has authenticated.
I can't tell you how to present your case.
I'm not asking. I just want to know, am I limited there?
So what objection? I don't know what your case is going to be. There are 3 specific issues of law that I
Understand.
However, the defense then wishes to present the motion for new trial. Given those rules, we are here to address today.
And I want to make an inquiry with regard to such things as the motion or the notice of intent to present juror testimony, which we filed with the clerk without the exhibits because we were trying to protect juror anonymity. I would be permitted, I assume, to file that with the exhibits attached after this hearing.
So I have not been asked to seal it.
I'm sorry?
I have not been asked to seal that at any point.
Well,
because of that, at this point, the court can't sua sponte seal. The court has tried very hard during these proceedings to ensure the anonymity of the panel for a variety of reasons that I will get back to. And that has been respected throughout. If, and I would suggest this may be one of those cases, there is something that is being submitted to the court that any one of the parties believes may create an issue, then for the jurors, then that needs to be submitted to me with a motion to seal. I need to hear from the parties, but then I need to have a hearing under the rule to ensure that the public interest is not outweighed, or that the public interest is outweighed, I should say. And then I'll seal them. But it's not the court's duty to just seal records.
I fully understand that, Your Honor. And frankly, from the defendant's standpoint, from Travis McMichael's standpoint, it doesn't matter to us whether it's sealed. But given what the court has just said, we move to file the entire motion with exhibits under seal. It was filed, Your Honor, with the court. The notice of intent that was filed, let me get the stamp. The stamp we have from the clerk's office is that the covering motion, not the exhibits, were submitted and filed with the clerk of court on October 7, 2024 at 4:28 in the afternoon. We would move to allow us to submit now the exhibits under seal, given the court's observations.
We're going to have to address that. I need to give everybody an opportunity to consider that, as well as the
I want to make it clear from our position, we don't care whether it's under seal. I'm trying to abide by the court's concerns.
What we're going to do for the time being is the notice of intent will be in the record. We'll hold off on the attachments until the court's had an opportunity to consider the motion to seal.
Thank you, Your Honor. I believe that's all we have preliminarily. I will present at the appropriate time, and Mr. Lamar, who practices law with me, will present the testimony from Mr. Wilson regarding other subject matters. I'm just here to address the proffer. I will call Mr. Wilson for the proffer, and then he will, when we get back to the other issues, then Mr. Lamar will take my position. I'm very concerned under the rules what is necessary to authenticate. This is not a situation I've faced in 52 years with all of the anonymity. And so I'm concerned that I don't run afoul of any rule of this court and yet follow what I understand to be the law. And I believe my understanding of the law is that we need to proffer these affidavits as exhibits. And I'm sure that we'll proffer them under seal as well, because they're extensive and probably, according to the court's observations, they do not need to be available for public review.
Summary of what the statements were. The most material statements being part of the affidavit. So I understand what the proffer is at this point on those specific jurors, and just to be clear for the record.
The jurors 79, 380, and 580. I understand, Your Honor. Because sometimes I'm a little slow on the uptake. I think I understand the court's rulings. If I come close to violating them, it's not intentional. That's where I am. And also, we viewed the notice of intent. I called it a pre-proffer, just to give the court an understanding of why we believe that this testimony does not violate 606. So,
Sufficiently apprised of the court as to the issues. I've ruled on the three issues that I see were raised by the defendants proposed to call these witnesses. Within the context of the court's rulings, let's go ahead and move on to the motion for trial.
All right, then I believe Mr. Bryan is going to go first with regard to the substantive portion, and then we'll follow.
There's been some discussion during our brief status on motion for new trial was filed on May 22nd, 2024. The state has had an opportunity to file a written response. I received my email, so it was filed.
Yes, Your Honor.
So the matter is approved.
Thank you, Your Honor, and yeah, I'll do what everybody wants me to, go first, last, in the middle, somewhere. I filed my motion, Judge. My intent was just to present the issues that I thought needed evidentiary support that were required to be presented before appeal. I do not intend to relitigate issues already raised at the trial or pretrial, which just leaves the two issues of ineffective assistance of counsel.
So you're preserving everything in the motion.
I think everything was adequately preserved, all the other motions. I'm not going to ask. I know Ms. Dunkowski's brief got into many other issues that maybe were raised in the original motion filed by Mr. Gall. I'm just focusing on these two, and Mr. Gall's here, and I would just, if one of the bailiffs could sound for him, he's out in one of the witness rooms, unless Your Honor wants me to go get him.
No, that's fine. If we can go ahead and, Mr. Kevin Goff.
Call. I just call him Kevin, so I never got his last name. All right, if you could state your name.
Kevin Goff.
And what is your occupation?
I'm an attorney.
And are you licensed in the state of Georgia?
I am.
How long have you been licensed?
June 1987.
And do you generally practice criminal law?
Yes.
Briefly, can you just give us some of your experience as a lawyer?
I first was a judge in Montgomery, Alabama. Served law clerk for a year there. Private practice for a year. I came here to an assistant district attorney in 1989. Assistant district attorney to June of 93. I went into private practice at that time. I then made private practice until August of 2012, when I became circuit public defender for Brunswick District Circuit. I held that position until April or May of 2016, and went back into private practice, and I've been there since.
Is that, and at some point you came to represent Mr. Bryan?
Yes,
And you were in private practice at the time?
I was.
Were you appointed? Were you retained?
I was retained.
Now, I don't think it's a secret here that you knew that Mr. Bryan was subject to some criminal action or suspected criminal action in this county before you were hired?
Yes, I was originally hired for pre-arrest representation.
Do you recall when you first spoke with Mr. Bryan?
I don't. It was in probably in April or early May, but I can't be any more specific than that.
Okay, so Mr. Arbery's death was February 23rd, 2020. And so sometime, a couple of months later, we have a time span of middle of April to 1st of May.
The McMichaels were arrested, and I think at that point in time, the urgency of Mr. Bryan's situation became clear.
Now, do you recall the date the McMichaels were arrested?
I don't recall the exact date. I believe it was in early May.
Does May 7th sound accurate to you, or would that be consistent with what you recall?
That fits the time frame.
And we went over some of these timelines to kind of refresh your memory. So do you recall when you actually formally entered into any kind of a agreement with Mr. Bryan to represent him?
May 8th. There's a check dated that day and the agreement dated that day.
Now, prior to May 8th, did you have any conversations or communications with prosecutors, police officers regarding Mr. Bryan?
I don't think so. Prior to May 8th, my recollection is that either Mr. Bryan or his wife had reached out to me about his situation, and I encouraged them to seek other counsel at that time. That didn't work out. But it had to be around, well, May 8th was the day I was formally retained.
Would it be fair to say that you then talked with Mr. Bryan? I'm not asking you to repeat what he said, but talk with him about what transpired.
Yes, we probably had a brief conversation, maybe over the phone before that, but we really didn't get into the details of it.
Okay. And at some point, Mr. Bryan met with Agent Sechrist and made a statement.
Yes. I think if I recall correctly, when Mr. Bryan retained me, the GBI had reached out to him the day before, maybe, or the day before that, or maybe earlier in the week. They had reached out to him and they wanted to interview him. And he came to me because they were expecting an answer. And I think we put off the GBI. I think it was Agent Secrets, but we put the GBI off at least over the weekend, trying to get a better idea of what was going on.
So May 8th, you began your representation. The first interview is on May 11th. Is that?
I believe that's right.
So between May 8th and May 11th, did you have any conversations with any prosecutors, district attorneys, or police officers regarding Mr. Bryan's case?
It's difficult for me to recall that now. I can't really refresh my memory from that time frame. So it makes it hard for me to answer that. But I know that we would have talked and met and got the information we could. A lot of the information that was available was frankly from the media. Information leaked or appeared to have been leaked, whether from Glenn County PD, GBI, the Arbery family or their attorneys or whoever. There's no way at this point in time I can speculate on where the information was coming from. But there was information, there was a short snippet from the video that Mr. Bryan had made at the time of the shooting and had turned over, but I'm not sure he retained a copy of it. But there's a snippet of it, or a snippet of the video from the actual shooting that had made it in the media and a few other things. There was a lot of misinformation. I didn't really spend a lot of time looking at the Arbery matter until Mr. Bryan indicated an intention to retain me. I know that sounds weird, but this is my living. I generally don't pay attention to cases that don't involve me. So I didn't have a whole lot of information before Mr. Bryan.
As far as talking to anybody from whether it was the Brunswick Circuit or the Atlantic Circuit or the Cobb Circuit, you had no conversations between May 8th and May 11th?
With prosecutors?
Yes.
I don't believe so. I think I had made a point of pointing out that I wasn't getting any responses to inquiries. But at that time, from what I can see, technically, Juliet Holmes had just gotten appointed or just gotten into the case, and Mr. Durden had exited or was just exiting. The GBI had different reasons why I was having trouble getting in touch with people, and those explanations were plausible at the time. It may also well have been that they just didn't want to communicate.
Prior to May 11th, then is it fair to say you attempted to contact somebody from the Cobb County District Attorney's Office, but received no reply?
I'm pretty sure I reached out to a prosecutor. I can't recall who.
Now,
But I do know that I mentioned to the GBI more than one occasion that I was having difficulty communicating with prosecutors and concerned.
was it Agent Sechrist that contacted Mr. Bryan, to your knowledge, about doing an interview?
I can't recall whether Agent Sechrist contacted Mr. Bryant or another GBI agent initially contacted Mr. Bryant and let him know that Mr. Seacrest wanted to get here. That much I can't recall. Mr. Seacrest seemed to be the lead agent at that point in time dealing with Rodney Bryant. And there was a lot of investigators down here. The GBI had temporarily taken over offices in the DNR complex, for lack of a better word, off to the side of the city near Bridge. And there seemed to be a lot of people. But I believe Agent Seacrest was the lead officer with respect to Rodney Bryant.
Did you speak with Agent Seacrest then prior to May 11th?
I think I did. I'm pretty sure I did. It's possible it was text instead of calls, but I'm pretty sure. Yeah.
Any other agents you recall any specific names of anybody you might have spoken to?
Agent Dial was kind of out there, but I can't specifically recall what his exact role was with respect to Mr. Bryant in his time frame. But there were a bunch of DBI agents floating around.
From May 8th to May 11th, whatever time the interview started, did you speak to anybody in the Glenn County, the responding police department's office about anything they may know about the case?
I can't tell you that I spoke to any particular Glenn County Police Department officer. I made some inquiries around. This is a small town, but I can't recall any specific conversations with specific individuals at this time.
Okay. And it seems that the freshest thing in your memory is Agent Seacrest. So with Agent Seacrest, did he give you any information about anything he uncovered in his investigation or the police department or GBI's investigation to that point in time prior to the May 11th interview?
I don't recall Agent Seacrest sharing a lot of information. That's generally not how this works. They generally try to give out as little information as they can while getting as much as they can. They did have to share some details because they couldn't really ask Roddy questions without sharing it. They had to inform him of some things so they could inquire, but they didn't share a whole lot. I do remember being told, don't believe what you read in the papers, things like that.
Had you received any, back it up, were you aware that Mr. Bryant had made statements to the Glenn County Police Department prior to May 11th?
Yes.
Were you aware those statements were recorded?
Yes.
Had you seen those or heard those prior to May 11th?
I believe that small snippets of the body cams may have been in the media by that time, or information from them had been put out there in the media from whoever. But I don't recall any specifics, but I know there was a lot of information that the vast majority of those interviews that I did not have access to.
Would you rely on any media reports in representing Mr. Bryant or any other client you may represent?
Depending on the circumstances, I'll utilize any resource that's available if I feel like I can rely on it.
Would the best evidence of what Mr. Bryant said be the actual interview or a media report of what they have garnered from some leak?
The absolute best information as to what Mr. Bryant said to law enforcement, the best information would be the body cam videos themselves from the officers. And there were multiple officers on the scene the day of the shooting. And some of their cams picked up more of conversation, some of those picked up less of the conversation. I also had the benefit of Mr. Bryant as my client to recount as best he could what was said. Now, people tend to recall things the way they want them to be. And in retrospect, maybe his initial explanation of what was said was a little more favorable to him, slightly more favorable than the actual videos turned out to be. But all in all, legitimately tried to the best of his ability to tell me what had gone on that day.
Would that be unusual that when a defendant tells you was not actually what is reported during the statement?
Clients, a lot of lawyers all the time in the initial statements of the case, but in this case, for the most part, I thought Mr. Bryan was very truthful. I thought he was, to this day, I can't say that I ever caught Mr. Bryan in a lie of any kind. I mean, he may have embellished or understated things, but generally speaking, we had a very good relationship, and I never had problems with him like I did with some clients where I'd walk in the courtroom and get blindsided.
In addition, not just lying, but maybe memory issues or perceptions or stress of the events, or those other factors that weigh in on whether or not Mr. Bryan or any other of your clients are able to recount exactly what they have informed the police?
Yes, clients under stress are often less reliable reporters of events. Mr. Bryan was under extreme stress, and he is an individual I could certainly say today, if I couldn't say in May of that year, certainly someone who doesn't respond especially well to stress. That was certainly a factor that entered into decisions made later in the case. So, for example, whether he would testify.
In addition to the body cam on the scene, did he not also go to the Glenn County Police Department and make a formal statement as well before your representation began?
I think he might have made 2 statements.
So going to this May 11th interview, do you recall any conversations you had with Agent Seacrest about the parameters of this interview?
Yes. As I explained, I was trying to buy time, among other things. I wanted to get a polygraph examination for Roddy. And I wanted to be able to do what I could for Roddy, and the more time I had, the better off I was. On the other hand, it seemed pretty clear, having already arrested the McMichaels, that the GPI would have probable cause to arrest Mr. Bryan if they chose to do so. He was subject to being arrested at any moment. So pushing back the cooperation with the GPI beyond a certain point was something that would trigger his arrest. So that was a balancing act. Once Mr. Bryan was arrested, it's difficult to unring that bell with the entire world watching what you're doing. Once the GBI gave the charging decision and arrested Mr. Bryan, that was kind of, in many ways, an irrevocable decision. There was no coming back from that. So I didn't want them rushing to do that either.
Prior to the May 11th interview, were you aware of what, I guess, subsequently came out at trial and probably learned through discovery? Some of the Glenn County police officers, when they interviewed Mr. Bryan, said that Mr. Bryan recounted that he boxed Mr. Arbery in, things of that nature. Were you aware of that before the May 11th interview?
I don't know if Mr. Bryan used the word boxed in, but he was reasonably candid that some of the things that he said to the GPI probably wouldn't sound good. He's just not a very capable person. I don't know that the full exact flavor of some of that stuff was fully there. I mean, it was a little worse looking at the statements that went. It was somewhat worse than what I had hoped for. But I can't say that Mr. Bryan misled me as to any of that. So I'm not sure if that's helping you. I'm trying.
I just want you to testify as to what happened, what the actually transpired. So when Officer Minshew testified during the trial that Mr. Bryan said he blocked and cornered Mr. Arbery during the chase, and then went on to how many times and that's according to Officer Minshew, of course, that Mr. Bryan blocked Mr. Arbery in. Were you aware of that before May 11th?
I can't recall whether what I can say is this. Mr. Bryan did alert me that there were things in the statements he made concerned about that were probably not helpful. Did I have the exact full flavor of it? Not necessarily, but there were real issues with what he had said to the police. Among other things, my recollection is that Greg McMichael was doing his best at the scene of the crime to dictate's not the word for it, direct the officers in their work. And, you know, I always felt that Mr. Bryan, what he said that day was partly in response as much to what Greg McMichael was saying as to what he was actually seeing, doing, and looking at the videos, the body cams from that day. I felt that some of the things Roddy said were probably not exactly right, but he just kind of went along with what was going out there. The problem is you're stuck with that. When you make a statement to the police, you have to live with it. There's no coming back from it. It's not something you can really argue to the jury.
Would it be fair to say that you did not actually speak to Officer Minshew before May 11th?
I'm pretty sure that I did not talk to any of the Lake County police officers prior to May 11th.
I'll just ask, that would include ex-officer Lowry?
I don't recall talking to Officer Lowry.
Now, I've asked you about this blocking and this boxing in. Did you ever advise Mr. Bryan not to use language like that when he submitted to this interview with Agent Seacrest?
I can't recall telling Mr. Bryan what to say. I mean, we all always tell our clients to tell the truth, and if you can't tell the truth, maybe you just shouldn't tell it. As far as word choices, it's possible that I suggested other ways to say the same thing. I can't rule that out. When we did the video with Mr. Bryan on the 13th, I mean, I think I interjected at one point, we restarted the video because one of the GBI officers started out saying something that didn't sound like it was going to come across very well in the court. So I can't rule that out, but I wasn't telling Mr. Bryan what to say any more than I was telling the GBI officer what he could or couldn't say. And certainly in suggesting that if I remember, we went back, like we drove like 10 or 15 feet and we pulled back in and started over again. It wasn't like I was trying to tell the GBI officers what they could or couldn't do. I didn't have that far.
Now, you testified that Mr. Bryan was concerned about, before this May 11th interview, I think, is what your testimony was, that he was concerned about some of the things he may have stated to the police before your involvement? Is that?
I think he was concerned. Yeah.
Was that something that was specifically part of that concern, the boxing or boxing in?
So I'm doing the best.
Okay, that's okay.
I'm doing the best I can. I don't specifically recall whether he was concerned about the boxing in. I know that Mr. Bryan was concerned that his. Are you really sure you want to get into that? I think Mr. Bryan was concerned that some of the statements that he gave to the GBI might, in retrospect, not look so good. You know, whether that's specifically boxing them in, trying to run them off the road. There was language that Mr. Bryan used in his statements to the GBI that day, on the day of the shooting, on the side of the road, that were not well thought out by Mr. Bryan. And I'm not sure to this day that they were even true. But Mr. Bryan was responding that day to things that were around him, what he was seeing and hearing. He thought that day that he was with the good guys. Okay? He thought he was doing a public service that day. It didn't dawn on Mr. Bryan until well after the fact that he might have actually done something that other people might think was not heroic. He thought he was the good guy. And I understand why.
Well, in response anyway, Mr. Bryan's statements were not only were they played for the jury, but the officers testified to them, and I'm speaking about pre-May 11th. Is that correct?
The statements from the day of the shooting?
The day of the shooting and subsequent interview before your involvement.
Yes.
So that came out. So I'm not asking you to reveal anything that wasn't already made known to the public as far as his interviews.
Okay, but when you're asking me about what he's telling me, he was aware that, in retrospect, that he had created some liability for himself and some of his word choices when he spoke with the GBI. And I think that objectively, when you look back, what was said on the side of the road and what was said to the GBI after the shooting, some of his word choices were poor and made it sound like he had been more aggressive than had in fact been the case. And that really put him in an awkward position. There was no question that the GBI had probable cause. If they chose to arrest him, he was subject to being arrested. And if he was arrested at that time, it was pretty clear that he was not going to be released from jail, no matter how many motions for bond would be filed on his behalf. So he had some stark choices to make.
Was there any suggestion, and I shouldn't use that word suggestion, strike that. Was there any advice to avoid using certain language that may have been put Mr. Bryan in this bad light before that May 8th, May 11th or 13th interview?
I don't recall specific advice of that specific wording, but did we take the time between May 8th and May 11th to review what he would say if he spoke to the police? We sure did. Did we take more time? We only covered on May 11th certain very narrow subjects because I was still trying to catch up in understanding the case, which is why we were limited the first time and we came back on May 13th. So did Roddy and I discuss what his testimony was going to be on May 11th and May 13th and what his statement would be? Yes, we discussed it at length. Did we discuss how he could truthfully present that in a way that would minimize how he appeared? Sure, we discussed that. You can say the same thing in many different ways and come across much worse in some ways than others. For example, if you're going to do a reenactment video of something that happened in a racially sensitive case, we try not to use words like spook, because in some circles that can be interpreted the wrong way. Does that make the person using that word a bad person? No. Does it make it a lie if they don't use that word? No. There are word choices that are not substantive. But yeah, we spent a long time discussing what he was going to say, both on the 11th and on the 13th. And every step of the way, the choice was always there not to go forward or to stop speaking at any time.
Now, between the May 11th, May 11th you testified was limited, and at some point, Agent Seacrest says, not enough, I need more. You recall when that was? And I'm paraphrasing.
That was never the discussion. The discussion was, I needed more time to allow Roddy, Mr. Bryan, to give an unrestricted interview because I was catching up.
No, I'm referring to Agent Seacrest. I apologize. I'm referring to at some point during or after the May 11th interview, Agent Seacrest wants another interview. That's what I was asking about. When did that come about?
We always knew that they would want a second interview. It was never a question that he was going to speak to them once, and that was it, because it was limited to begin with. It was always the expectation that there would be a second interview. If the GBI wanted, they could have walked out and said this was a waste of time. But there was never an expectation that Roddy's discussion with the GBI was going to end on May 11th, although we had the option, and we discussed it while we were there on May 11th. We took, and they may or may not be documented in the recorded interview from that date, but there was a lengthy conversation prior to that interview on May 11th. There was at least one recess, maybe two, on May 11th, where I had conversations at the hallway with Mr. Sechrist, and I had conversations at the hallway with Mr. Bryant, because there was always the option of terminating the interview.
So prior to May 11th, I just want to ask, was it, Agent Sechrist didn't say, hey, I want you to come in for the first of 2 interviews, did he? It was just come in and I want to talk to you. I want to talk to your client about some matters that arose, have questions for him.
Mr. Sechrist would have been, Agent Sechrist would have been happy to have one interview. He wanted to have a full range of discussion with Mr. Bryant. I couldn't give him that because I wasn't comfortable on May 11th with that. But it's not like we did the one and then suddenly it's a surprise there was going to be a follow-up. The question, what I'm trying to tell you is, it was anticipated that we were going to be coming back after May 11th.
You believe that Agent Sechrist would want more information, not limited.
Well, yeah. The first thing he had to assess is whether he wanted Roddy as a witness. I mean, that's part of the process. And if the person is unable to function as a witness, then that's the end of the process. And frankly, if I recall, Mr. Bryant had some issues at the beginning. I haven't reviewed the transcripts and I haven't reviewed the statement. But I think we recall that there was some issue. Roddy was extremely nervous maybe, and we had to take a recess. And there was some question as to whether or not we should proceed or not. And I think we came back in and we started up again.
You know, going back to the original question, which was, at what point did Agent Sechrist ask Mr. Bryan, or ask you on behalf of Mr. Bryan to submit to the second interview? When was that?
And I'm trying to answer as best I can.
Okay, sure.
They wanted the ability to have a complete discussion. Police officers don't like to have restrictions on interviews. And sometimes you can't do that. They always have the option to arrest them. But the idea that we came in and it was a surprise that we were going to come back again, that's not true. It was kind of expected. The first interview was Mr. Bryan was going to see whether he was comfortable, and the GBI was going to see whether they were comfortable. The first interview, topics were relatively limited. If he came back, it was going to be a much more open conversation.
I understand. I think we've established though that Agent Sechrist didn't ask you to come in, hey, can you all come in on May 11th and then come in 2 days later? You come in on May 8th, I'm sorry, May 11th and May 13th. You come in on May 11th, at some point, there's got to be some request for you to come back on a different date. And that's just what I'm asking, when was that done? Was that done right after the interview, in the middle of the interview, the next day?
I can't recall when the decision was made to come back on the 13th. I can tell you that I can recall trying to postpone the second interview on the 13th. I wanted more time. There was, Justice Department had begun showing interest in the case. And that creates a whole other level of complication. At some point, the U.S. attorney showed up for a press conference and was standing in the background, if I recall. But however it came up, I wanted additional time, and I couldn't get it. And at that point, it was either we were going to submit to an interview or not, and then they were going to make a decision.
The first interview was May 11th, the second was May 13th. So would it be fair to say that there was some request by Agent Sechrist on either May 11th or May 12th to come back on May 13th?
I don't know whether he initiated the date, I initiated the date. What I'm trying to say is it had been anticipated the GBI was not settling for the snippets of the limited subjects that we had. I think it was anticipated, if everyone was happy with what happened on May 11th, that we would come back at a later date, whether that was the 12th, 13th, or 14th. I don't know that that was clear up front. It ended up being 13th.
Well, it almost sounds like your answer is that it was maybe your idea to come back a second day, or was it Agent Sechrist?
It was a mutual decision. Roddy had to decide if he wanted to cooperate further, knowing the risks, and the GBI FBI had to decide whether it was worthwhile. But I'm really kind of confused.
I guess it's like one of those things with a mutual breakup. Well, somebody had to initiate it, really. Come on, nobody just at the same time says, hey, let's break up. At some point, somebody had to say, either as attorney, Mr. Goff or Mr. Bryan, we need to cover some more things. Can we come back in a couple of days? Or Agent Seacrest says, listen, that's not enough. We need a little more information. I don't think it's just that both of it's kind of, and if it is, hey, I'm wrong. But I don't think at the same time, Goff and Seacrest are talking over each other going, we need to talk more. So somebody had to raise it first. And that's what I'm asking. Who raised it?
I can recall.
Okay.
I mean, I've told you this, Mr. Johnson.
Okay.
I mean, a lot of the communications were by text between myself and Agent Seacrest. That phone broke, and without recovering the information from it, the text from it, it's hard for me to piece together the sequence of exactly when Mr. Bryan retained me, exactly and how and when we set up the interview. A lot of that is in text, and only a sliver of those texts are part of the record in this case. I vaguely recall a handful of those texts being used during the trial, maybe on the Jackson v. Deno, but I don't have access to those, and frankly, Agent Seacrest has his phone, and whether they were preserved or not, I don't know. But without having the benefit of going back through the communications in that time frame, it's hard for me to be more specific.
Okay. So you don't recall whether or not it was you or Agent Seacrest who initiated the May 13th thing?
The GBI always wanted more information. That's my recollection. And that I've never known a law enforcement officer that didn't want an opportunity to speak with the defendant. And there were other issues out there. There was certainly other information that Roddy could provide that maybe they weren't aware of, like the night owl videos. I'm not sure, but it may be that we volunteered those. Distance of those. There were issues with Roddy's cell phone, and if I recall the video, because the police couldn't get the video, they got a snippet on the side of the road that day of the shooting. Then Roddy brought the phone back a second time, and they had issues. Mr. Bryan may have brought the cell phone back to them a third time before he retained me. But they were still apparently having some issues. They wanted access to the phone. And there were a number of things that the GBI was interested in besides Roddy's actual statement.
Okay. Between May 11th, when the interview concluded, and the second interview on May the 13th, were you able to obtain any evidence or statements or videos or recordings from the state, the attorney's office, the police, or any other source that gave you more information on the case other than what Mr. Bryan was able to provide you?
I don't believe so. I mean, it's possible that Agent Seacrest provided something somewhere along the way that week to help Roddy refresh his memory, but I don't recall it.
So from May 11th to the May 13th interview, were there any other attempts or discussions with the Cobb County District Attorney's Office?
I don't believe so. I believe that it continued to be, I could be wrong, but I think it was more or less a blackout situation where we couldn't get in touch with them. And it was concerning.
Then it's fair to say that your communications with state agents, officers, was strictly with Agent Seacrest during this period of time from May 8th when you began your representation to May 13th when the second interview concluded?
Agent Seacrest was the primary GBI agent who was responsible. There were always other officers around.
I'm speaking of who you had communications with. Would it be just Agent Seacrest?
Some of those officers were present on May 11th. Some of those officers were present on May 13th. I can assure you, Agent Seacrest didn't go in Roddy Bryan's house alone. And I can't rule out the possibility that there were conversations with other agents as well. But the ones that I remember, or with agency.
And when I'm saying that, I'm referring to communications outside the actual interviews.
The communications that I remember would have been with agency.
Was it, did you, with Agent Seacrest, you attempted to, your goal was, I take it, to have Mr. Bryan a witness as opposed to a defendant? Would that be fair to say?
Oh, absolutely. Mr. Bryan's much better off being a person of interest or a subject and a witness than being a target of an investigation.
There was, prior to either interview, May 11th and May 13th, there were, or I should say, were there any agreements to that effect?
There was never a legally binding agreement for Mr. Bryan's testimony or his cooperation. And Mr. Bryan was well aware at all times that we never had that. Now, at least in this part of the state, there's a long history of what we call non-deal deals. Okay? Sometimes the prosecutors are involved in those directly. Sometimes they're not. In a non-deal deal, at least in theory, if you're a prosecutor and you believe in that sort of thing, you don't have a deal, but you're getting the benefit of the deal without any of the liability associated with that at the trial of the case. And in this case, this wasn't a situation where Mr. Bryan was seeking a deal in the sense of a plea agreement, because Mr. Bryan wasn't prepared to plead guilty then. Or was this a case where Mr. Bryan was going to be obtaining immunity from prosecution? Because among other things, it was way too early in the case to have a discussion about immunity. And you also had the federal investigation looming as well. And any deal that was struck with the state, you'd also got to run that by the Justice Department, who shockingly was very reticent about committing to anything about anything in this case. But there was a discussion, and I think I mentioned it to you this morning because I went back through my notes. And maybe that's what you're asking me about. I don't know. But I do recall that. Let's see if I can find it.
Well, I'm just asking in general, was there any deal?
Well, obviously, we wanted the state to publicly come forth and say that Roddy Bryan was not a target of their investigation, that he was merely a witness. And there were various reasons for that. And Agent Seacrest did his best to walk that fine line between being encouraging and putting forth the deal. And if you want, I will look and I can find my notes of what the words were and the context. And you can decide what the significance of that is. It'll take me a minute to do that.
I think you've answered the question. I mean, I get it that Agent Seacrest, you're testifying, seems to me that it's fair to say that Agent Seacrest led you to believe that he was leading you on so he could get more testimony, get more statements from Mr.
He was certainly encouraging Roddy and I to believe that there would be a benefit to Roddy. But again, did he cross the line? I don't know, which is why I was going to suggest if it's relevant that I go find my notes as to exactly what transpired. But I'm just a witness.
I mean, I think you've answered the question. If you feel you need to do that to further explain your answer, you're certainly able to. But I think it's clear on what your answer is. But
if I have the opportunity, I would like to.
Go ahead if you feel.
Well, let's do this. Since we're going about. Yeah. Let's just go ahead and take 10-minute recess.
For your Honor's information, I have about probably 5 minutes left on this issue, maybe less. And then, so that would take the direct on that one issue. Then I would move on to the second issue, just so you understand, just for timing wise.
All right. While the court starts to take a break, we're just going to hear a word from our sponsors and we're going to get right back to the next portion where we don't really have to take a break like when we're watching the lives.
The real estate market often seems like a distant world where only an elite of experts is successful. In a time of so much uncertainty in the air and bad news, realist investing can seem intimidating. But today, I want to tell you that if you make the right decision today, you can enter the real estate market from the back door. Bad credit record? No credit at all. Do you dread the idea of having a home loan? Do you dream of owning investment properties? You are in the right place and right time because we have created a program which is a tax lien and deed investment online course of only 14 hours. This course is specially designed for people like you who have big dreams. You will learn at your own pace and everything from your home computer. This is your chance. Join our membership for $19.99 a year. What are you waiting for? Visit our website primetimehomebuyerBuyback.org and sign up today for course access.
All right. All right. Let's get back to it. Thank you for being here tonight. You know, I love this type of content and I enjoy watching it with you. I want to make sure we don't miss anything.
All right, we are back on. All defendants present, represented by counsel. Witnesses on the stand. Mr. Zell.
Thank you, Your Honor. All right. Back to where we were as far as you're holding your hands up. So if you have further explanation, go ahead.
Yes. I'm looking at some notes from the trial. It looked like they were notes prepared prior to whenever the Jackson v. Deno hearing was in the case. And I haven't reviewed the transcript from the trial, so I have no idea what's in there and what's not. It's 10,000 pages about. But my notes reflect my recollection that Agent Seacrest, somewhere on the first day, either before we started or on a recess, I'm pretty sure there was at least one recess, that he did say to me that Roddy was not a target, but that GBI director and the DA were uncomfortable at that time saying so publicly. Now, to be fair, I can't say 3 years, 4 years later, whether Mr. Seacrest was saying that the GBI felt that said that he was not, whether he was speaking for the agency itself or whether he was simply airing a personal opinion, to be fair. It did suggest that the GBI and the district attorney were in agreement with that, but he's saying that they were uncomfortable saying so publicly, and what that kind of means is that it's just not really there, and that's what I told Roddy. He didn't have any. There was no. What's the word for it? That statement wasn't going to mean a whole lot if the GBI decided to prosecute him. And separately from that, in the interview room, before the interview started, I expressed, and this would be May 11th, I expressed concern to Agent Seacrest about the statements being made in the media about Roddy, that mostly coming from the Arbery family, not from law enforcement, that Roddy was the devil or he was evil or a whole bunch of really unflattering things. And obviously they were very interested in Mr. Bryan being prosecuted. And Mr. Seacrest advised in the presence of Roddy that the mother, Wanda Cooper Jones, was reasonable and that they felt that they would be able to work with her. And Obviously, those are things that Roddy would have considered in whether or not to cooperate further. Again, I'm pretty confident that I told Roddy any number of times that we did not at any time have a deal, and that they were always subject to going in a different direction. Now, I have no idea how much of that came out. I do vaguely recall during the Jackson v. Deno, where the discussion of his statement, Agent Seacrest did his made it best to sound like the GBI wasn't even interested in hearing from Roddy, that it was all defense counsel's idea or Roddy's idea. That was not true. I don't know that it matters, but those notes reflect my recollection of what actually happened. And so in response to your question earlier, that we were the ones insisting on the interview, I vaguely recall that might have been Agent Seacrest's presentation of that during that hearing, or that was the implication, but that wasn't an accurate rendition of what went on. The GBI very much wanted every piece of information that they could get from Mr. Bryan, and
Okay.
so
and just,
Yeah.
I'm sorry, did you finish your answer?
yeah, you had been
Okay.
been. That was the issue. Okay. There was this idea that we were the ones pushing the GBI to talk to him. That's not a fair representation of what went down.
And when you say, I'm going to circle back around to some of these matters you've raised now, but when you said 10,000, you're probably being very generous. It's up. So I get it that maybe some of this is not as fresh as specifics, but what you just testified, you're referring to when Agent Seacrest at the Jackson Deno said you called him to arrange the interview. You're saying that's not true, that Agent Seacrest was lying.
What I'm saying is I can't recall exactly who called who or who texted who, but what I can tell you is that the tenor of that testimony, that it was Mr. Bryan and I desperately trying to fall over ourselves to help the GBI prosecute Mr. Bryan, that was not a fair representation. I'm not saying that he's lying, but that spin did not accurately reflect the situation. The GBI very much wanted his cooperation, and they wanted it then. They didn't want to wait. It was the GBI who was insisting on getting this process done. Either Roddy was going to speak to them or he wasn't. And it wasn't me rushing to have an interview on May 13th. I was trying to find a way to put it off. And in fact, if I recall correctly, I can go look for it. I emailed the Justice Department, that's the U.S. Justice Department, trying to get their help in putting that interview back.
Okay. So just
I don't need to find it. I wasn't rushing in on May 13th. I would have taken as much time as we could get. And it just wasn't an option.
So just for the record, Mr. Kowski, for your honor, that reference I referred to with Agent Seacrest was the 1 year anniversary of that second interview, volume 1, May 13th, 2021, page 128, when that was arose. You're speaking of the Jackson Deno hearing, when the agent testified about that. Okay. All right. So now, and circling back again to something else, was that you said down here, that was before the break, and I hadn't had a chance to, we took a break before I had a chance to follow up on that. Down here, you said it sounded that you were talking about, you had, I don't want to say deals, but understandings with maybe the law enforcement as opposed to the prosecution office. Is that what you're referring to?
Non-deal deals is a prosecutorial / law enforcement practice of working out arrangements to get the cooperation of witnesses without having to own it. Now, you can do that unethically. You can have the DA and the defense lawyers sit in a room somewhere, wink, wink, nod, nod, we're not going to tell anybody. That's a non-deal deal, I suppose. More often, there is no deal. It's contextually. Other times, it works through law enforcement. It's a thing. It's highly unethical. It's unethical for prosecutors, and it's unethical for defense lawyers to have a deal in place and not disclose it. At least for the prosecution, it would be considered a violation if they called the witness to testify. But these things happen. And sometimes, Mr. Zell, you're a criminal defense lawyer, sometimes you have to cooperate without having even a non-deal. You just have to do, quote unquote, the right thing and hope for the best. Sometimes that is the option that is presented to you. And what I'm trying to tell you is that Agent Seacrest walked that fine line between having a deal and not having a deal. And I can't say sitting here that he crossed it. A deal has to be approved by the prosecutor. And it was abundantly clear that the prosecutor was not involved in that discussion. That was basically Mr. Bryan speaking to them, hoping for the best. And he was aware of that. And there were subsequent discussions about that in the car, riding around when the reenactment video or the path of travel video is made. And then Mr. Bryan was still concerned, as I was, all through the process, that they could turn around and arrest him. And in fact, he turned around and made some comment about it. And the officers, I can't say Officer Seacrest was laughing, but I mean, the one or both of, I can't remember if it was one or two officers in the back of the car, but it was almost like a joke because they're trying to reassure Mr. Bryan that they're not going to prosecute him. But again, they haven't promised not to prosecute him. We have no agreement that he won't be prosecuted. And Mr. Bryan is aware at all stages of this, that there's no such agreement in place and they can still turn around and prosecute him. But obviously when he's sitting there going through the path of travel or the reenactment, however you want to describe it, he's certainly hoping he's not going to be prosecuted.
And it would be fair to say that once, if one of these, I think you said Mr. Bryan asked that maybe multiple times, are you going to arrest me? Are you going to prosecute me?
He made comment. He didn't come out and directly ask the question, but he made comments expressing concern about that. He was very, very worried about being arrested. He had just bought a home, and if he got arrested, he was going to lose the home, and they did lose the home very quickly. I think it might have been a deed in lieu of foreclosure or whatever it was, but they lost the home very quickly. That was a hard thing for him to get. So he did not want to be arrested. And, that was a fine line that Agent Seacrest was walking. We were in the middle of a public relations storm. This case generated publicity such as I don't think I've ever seen before. I think there's a reference in one of the motions filed to the internet activity for this case, I think dwarfed the OJ trial, which I didn't think was possible other than the expansion of news media. But Roddy was very much concerned about his life. And there was a death threat, I think, in the mailbox. And some of this may have been covered in the Jackson v. Deno hearing. I don't recall. There was a death threat or a letter in the mailbox that was turned over to the GBI. There was a news crew in the neighborhood the day that video was being made, and the media had left because shots had been fired or there was a report of shots fired. There had been a rather uncontrolled parade through the neighborhood by those concerned about the tragic death of Mr. Arbery. They had Mr. Bryan had driven to Atlanta for the polygraph examination. Savannah for the polygraph examination, and reported, he and his wife reported that they had been run off the road or felt they had been run off the road. They were literally scared to death at the time, and they were being tried in the media at that time. And that was just egging on this hatred, public hatred for Mr. Bryan.
Certainly, if any of these times when Mr. Bryan expressed this concern about being arrested, had he actually been arrested?
No, Mr. Bryan wasn't actually arrested.
No, that's not. Had he been arrested, the interviewing would have stopped. You would not have continued on with any interview. Is that correct?
Oh, no. If he had been arrested, that would have been the end of that process. Yeah, okay. At least, at that time. You never know what's going to happen down the road.
And then the last thing I want to circle back to is that you had, when you testified when we first came back from the break, that if the GBI decided to prosecute him, in fact, the GBI doesn't prosecute, it's the district attorney's office that prosecutes, right?
Technically,
Yeah.
the district attorney's office makes a decision. But Vic Reynolds was, if I recall, the former district attorney in Cobb County, and that and the fact that he was director of the GBI, I imagine he had some say so in the prosecution. And who was prosecuted, I don't know. I wasn't there. But I do know that our dealings were mostly with the GBI. We had very little contact with counsel. We couldn't get it. And my recollection was that Mr. Agent Seacrest was supposed to come and see me at the St. Simon's Island Starbucks after they had finished up speaking with Roddy on the 13th and doing the other things they were supposed to do. And I don't have the text in front of me, but either he wasn't coming, his superiors wouldn't let him come. I forget what the explanation was. And that was the end of that.
And then Mr. Bryan was arrested on May the 21st, about roughly 8 days, a week later after the second interview.
Yes. The GBI, I can't remember if they texted me or they emailed me, but they let me know that they wanted him to turn himself in, and we arranged for him to do that. That was what we agreed to do if they decided they were going to pursue it. I certainly didn't want them coming in the middle of the night with the SWAT team to come get him.
Okay. And I'm going to move on to the second issue now, the mistake of fact issue.
Yeah.
And just ask you about that. Is that something that you had considered during your preparation for the trial? Or what I'm really getting at is, when did you first consider that as a potential defense or jury charge or argument that you could make in this case?
Are we talking about mistake of fact?
Yes, mistake of fact, yes.
I can't remember when it first came up. My recollection is that either Bob Rubin or Jason Sheffield had come across something for just happenstance, came across something about mistake of fact. And they had sent that to me. And I mean, I was already aware of the concept, but they had sent me, it was interesting. And one thing led to another, and that led to the jury charge that was submitted, which was, it started out as part of a citizen arrest charge, which started out as a brief or a memo on that. And there was good faith defense and mistake that were weaved together as part of the larger charge. The judge said no. We came back and we submitted good faith defense and mistake of fact, the charge we wanted separately. And the judge said no. And Ms. Dunikowski had said she was okay with the pattern charge, which was not really what I wanted, but we take what we can get. And so my intention was to argue mistake of fact at the trial.
Did you, in fact, prepare that in your closing arguments before you made the argument to argue the mistake of fact?
Yes. The closing argument, which I did actually skim through last night, is about 140 pages, I think, of transcript. I was the last counsel to give a closing. Well, next to last. I think Ms. Dunikowski opened and closed. I was last defense counsel, and this was hours into the presentations of the day. But I had a series of notes. I had typewritten notes. I had handwritten notes, and I had notes to say something that I hadn't written out, just to come up with it. And I included the mistake of fact pattern charge, and my intent was to argue, and I had it basically I took the charge I submitted and didn't get, which was more helpful. And what I was going to tell the jury what this means is, and get it in for what I could that way, and then expound upon that. As the closing arguments went forward and issues were covered or not covered in different ways, I adjusted the order of presentation and the arguments that day as we were sitting here. And somehow in that process, the mistake of fact argument, such as it was not given. And I believe I let Mr. Bryan know. I can't remember when I let him know, but at some point I let him know that, I had figured out that that had not taken place and that that was not a strategic decision, that was simply an error, a blunder on my part. And for that, I apologize. I apologize to Mr. Bryan then, and I feel bad about it to this day.
Regarding, you mentioned the good faith, and it's something that you had requested, but that in fact was denied. Is that your request was denied?
It was.
Okay. And so Judge Walmsley actually did not instruct the jury on that particular point of law?
I believe he declined to instruct the jury on it. I argued it anyway, as best I could. And I'm thinking that I probably would have addressed the mistake of fact. Originally, I probably would have addressed it right after the good faith defense. And I don't know why that didn't happen.
And the mistake of fact was something that Judge Walmsley actually granted. Right?
He gave us a charge. It wasn't the charge I wanted. It didn't really. It had limited, the pattern charge and mistake of fact had limited utility in my judgment, but I went with what I had, or I intended to. But that argument it's just not there.
In your practice, since you didn't do it in this case, when you do obtain a jury charge on some defense, an affirmative defense or a quasi-affirmative defense, like, I don't want to say quasi, but a quasi, like one like alibi or something, is that something that you normally would argue if the judge is going to instruct on it?
I can't say that. A lot of times as defense lawyers, we request charges that we have to request, but we don't really anticipate getting much mileage out of. There are other times when we request charges and we're just going to throw them out there hoping that a jury, the way I would describe it is squirrels. You got a juror just going off on a tangent that no one ever thought of. The more charges you discuss and the more stuff that's in the charge, the more likely it is the jury will go in an unanticipated direction. And sometimes it turns out they're pretty good directions. Sometimes not. But in this particular case, it was my intention to review the jury charge on mistake of fact, to discuss the charge I wanted without calling it a charge, because that wouldn't have gone very far, and then to elaborate on that. Now, to be fair, as I sit here today, I can't recall what the exact mistake of fact was that defense in the charges the court gave it would have hinged upon. But that's been 3 years. I had a plan then, and I just, but all I can tell you is that was not a strategic choice. That was an oversight. And it doesn't matter that there's 140 pages of other arguments. It should have been presented.
80 pages, but
I'm sorry?
80 pages.
80 pages? I'm sorry. I
That's
thought
okay.
it was longer
that's
than
okay.
that.
Unless my math is bad.
Minutes.
Unless
Maybe
my
it was
math
an
is
hour
bad.
and 40 minutes.
94:47 and 95:27 is what I have in my notes. But okay. But in any event, the last thing I want to ask you about, though, is aside from this, just Mr. Bryan himself. Did you obviously got to know him during the time of your representation? That would be fair to say.
Very well.
Okay. Did you know his educational background?
I did.
And what is his educational background?
Minimal.
And when you say minimal, I mean, minimal to somebody who's a PhD
He
in
might have
physics.
he may have graduated from high school. I don't recall sitting here today, but he was certainly not a academically inclined gentleman. He is more of a hands-on kind of guy. If you ask him to do something with his hands, he's very capable and he can do it. But he's just not a very good. He's not a very articulate speaker, and he gets frustrated when he can't find the right words to say what he wants to say. And really, more than anything else, his lack of verbal skill really hurt him on the day of the shooting and the interview that followed, because he really needed a lawyer. And had he had a lawyer before he made those statements to the police, I don't think he'd be here today.
Would it be fair to say he has no legal education, no legal training?
No, he doesn't.
And
he had certainly had difficulty following some of the legal concepts in this case. I think it was Bob Rubin had said at some point, you know, the Arbery, I still call it the Arbery trial. I don't mean to offend anybody by that. But it's like a law school exam question, a never-ending series of law school exam questions. And certainly it was difficult for Mr. Bryan to keep up with many of the nuances of the trial, of the case, and the legal concepts.
did you notice these issues or part of these issues when you first began representing Mr. Bryan?
Yes, it was obvious that he had a limited education. Matter of fact, I still get grief about talking about that.
It's no disrespect from either one of us. It's just a question I have to ask.
Yeah. I mean, he was of limited intellect. I mean, he's not retarded, but I think he did struggle in school learning. I can't remember the details, but he was never a good student. He's just a quiet guy. I mean, you know, the crazy thing about this whole case is his conduct on that day is just completely the opposite of everything he is and everything he's been in his whole life. I mean, really, it was 2 minutes of bad judgment in an otherwise remarkable life.
So just the last question. In the conversations you had with him when you prior to May 8th when he retained you and after and prior to his May 11th interview, this was abundantly clear that he had his communications were limited, or perhaps he was not the best communicator.
I think it was clear even by May 11th that his verbal, even in those 3 days, that his verbal skills were limited. I think it was an issue. Again, it's been a while, but I'm pretty sure that we took a break on May 11th during that interview, and Agent Seacrest and I went outside and spoke. Roddy was really nervous, and if I recall correctly, he was struggling a little bit, and Agent Seacrest, I think, was getting a little bit frustrated. And we took a break, and Roddy settled down, and, you know, we went forward. But yeah, it was clear that he was not the most verbal. I think, and maybe that wasn't clear earlier. I mean, we were in a public relations war in the first early part of this thing where people were talking about killing Mr. Bryan, trying to present him in a better light. And I think I ended up on an exchange on national television with, I think it was Chris Cuomo, because he was going outside the parameters that had been set. Because anytime Roddy spoke about this case, and there were really only a handful, but anytime he spoke, that was all carefully controlled. And Mr. Cuomo didn't believe in following those understandings. And I had to step in because I didn't feel that Roddy needed to be subjecting himself to a cross-examination by, of all people, Chris Cuomo, who was very capable. journalist. And there were risks in Roddy speaking to Agent Seacrest. There were huge risks. There were risks that we didn't know exactly what he said on the side of the road. We didn't know exactly what he said when he went to the police station. And he had some memory, but we all know those memories. We remember things the way we want to sometimes. I was aware of his limited ability. But frankly, in some ways, you know, as a result of having given those interviews, which he was, by the time we got to the end of the trial, he was just petrified, scared to death. Witnesses got up here, prosecution, defense, and just got blasted from all kinds of angles, from things they had no idea were coming. And watching how the police officers got cross-examined and some of the civilians got cross-examined, it was scary. So, you know, the fact that Roddy was able to put that version out there in some ways made it easier for him not to testify. It reduced what we were losing by not testifying. The version's not the right word for it. The statements that Roddy gave on May 11th and May 13th were much, much improved over the statements that he gave to the police when he really didn't know what was going on and he didn't know what his rights were. And in retrospect, I agree with you, Mr. Zell. That was a gamble in cooperating with the GBI. It was a gamble based on limited information. But in retrospect, that was the right call. It was the right call because, among other reasons, Roddy didn't have to testify. And it presented him in a much better light than he presented himself, certainly on the side of the road, you know, with that, and I don't mean any disrespect to the co-defendants, but that Greg McMichael, former law enforcement bravado. And, you know, I felt like Roddy absorbed some of that when he was out there and later. And when he came back and spoke to the GBI in May, his statements were more thought out. And I think in retrospect, I don't regret Mr. Bryan cooperating with the GBI for a moment. It was the right decision then, and it was the right decision now.
Hey, y'all.
That's all I have.
Just to let y'all know, it's not me. It's actually the camera that's freezing like this, so it's not me. Okay, y'all. It look a little weird.
I appreciate your testimony. Thank you.
Anything from the state?
Yes, Judge.
I grew up always on the bigger side.
I apologize. Give me 1 second because it was paused, but I really think, yeah, I really thought it was. I want to make sure that it wasn't on my side, y'all. So bear with me.
And I think in retrospect, I don't regret Mr. Bryan cooperating with the GBI for a moment. It was the right decision then, and it was
Anything from the state?
What's wrong with this thing?
absorbed some of that when he was out there and later. And when he came back and spoke to the GBI in May, his statements were more thought out. And I think in retrospect, I don't regret Mr. Bryan cooperating with the GBI for a moment. It was the right decision then, and it was the right decision now.
Okay. That's all I have. I appreciate your testimony. Thank you.
Anything from the state?
Yes, Judge. All right, Mr. Goff, where'd you go to law school?
University of Georgia,
Where'd you go undergrad?
College of William and Mary.
There we go.
And so basically you've spent your entire life practicing criminal law.
Yes. Well, since 1987.
1987. And you know that as a former assistant district attorney, it's the district attorney's office that brings the indictment and the charges.
Indeed.
All right, so let's go ahead and talk about the timeline briefly. You recall that on May 5th of 2020, Scott Ryfin was given the copy of the homicide video and released it to the public.
Yes.
Okay. And that is basically the day that kind of the media firestorm started, because now the public had access to actual evidence from this case.
Yes.
So at that point, Tom Durden was the district attorney pro tempore, and he called the GBI in to go ahead and investigate. Do you recall that?
Yes.
All right. So when the GBI is called in, Special Agent Dial comes in, and the McMichaels are arrested on the evening of May 7th, 2020. Does that sound right?
Yes.
And so you were then hired, because we know we have your fee check, from May 8th of 2020.
Yes.
Okay. So were you aware of the McMichaels being arrested?
Yes.
Okay. And so when Mr. Bryan came to you, he came to you seeking legal advice.
Yes.
And wanted you to do what?
To represent him. Okay. To represent, and I treated it as pre-arrest representation. The hope was he might not be arrested. And frankly, Mr. Bryan certainly did not have the money to hire anyone at that point to represent him a full Fiat murder case. He just didn't. So it was pre-arrest representation only. It was $2,500 retainer for hourly, on an hourly basis.
All right. So you're representing him pre-arrest, and the goal is to hopefully keep him from being arrested for murder.
Yes.
All right. And when you met with him on May 8th, did you then try and obtain as much information about what was going on with the case as you could?
I tried to obtain what information I could. I was limited in my ability to do that. Other than the media and Mr. Ryfin, there were no discovery rights at that time, and the information I had was limited and largely from Mr. Bryan.
Okay. And so Mr. Bryan, of course, is trying to recall what he said at approximately 1:14 on February 23rd, 2020, and what he said 3 hours later at the Glenn County Police Station, and telling this to you on May 8th.
Yes.
For anyone who has developed a brain or spinal tumor after using birth control shots, this is extremely important. I recently learned that birth control shots have been.
Y'all, that commercial right there is sick. I'm going to just tell y'all, I'm pretty much over it, okay? But we're going to move forward.
But he's doing it. He's giving you that information that he recalls.
Yes.
Okay. So you knew he had made statements at the scene.
Yes.
You knew he had talked to the police.
Yes.
You knew he'd handed over voluntarily his cell phone, and they had downloaded the homicide video.
Yes. Well, I knew they had tried to download it. I'm not sure when I found out that there were questions as to how successful it was.
Okay. And then you knew that he had taken his truck back over to the Glenn County Police Department and had them forensically examine it for fibers and fingerprints.
Yes.
Okay. And that he'd also given a recorded 1 hour long interview to the lead detective at the Glenn County Police Department approximately 3 to 4 hours after the homicide.
College graduate.
Yes.
Or in college.
And he was able to tell you what he recalled about the facts of the case, meaning his actions.
Yes.
Okay. And so we have May 8th, we go into May 11th. Now, I don't know if you'll recall specifically, but on May 11th, that very day, when you had the interview with Seacrest, District Attorney Pro Tempore Tom Durden recused himself. Do you recall that?
I know he recused himself. I don't recall the exact day, but as I testified earlier, there was a lot of stuff going on, and explanations for why district attorneys were not available were semi-plausible.
Okay. So that evening, May 11th, 2020, Joyette Holmes of the Cobb County District Attorney's Office was then appointed as District Attorney Pro Tempore. Do you recall that?
Yes.
Okay. And during this time, May 8th through May 11th, were you trying to reach out, meaning call Tom Durden and speak to him about your client?
I believe I made multiple attempts to reach out to the prosecution, but I can't recall the details.
Okay. Do you recall multiple attempts to contact Joyette Holmes in Cobb County?
I'm pretty sure there was more than one.
To speak to them.
But in the meantime, we've got the GBI via Special Agent Seacrest desiring an interview with your client.
Yes.
And so when Mr. Bryan actually met with you on May 8th, did he tell you that the GBI had already reached out to him, or was this something that happened after he hired you?
No, my recollection is that the urgency of hiring me was that the GBI wanted to speak with him.
Okay, because the GBI had been brought into the case on May 5th. McMichaels had been arrested the evening of May 7th. So here we are. Of course, the GBI is on the case. They're making phone calls to Mr. Bryan saying, we want to interview you.
Yes.
All right. And did you discuss with Mr. Bryan what a GBI interview would be like?
Yeah. Yes, I did.
Okay. And you went over the pros and cons of doing that interview.
Many times. Look, we reevaluated whether or not cooperating with the GBI in making a statement. That was a huge question that was constantly being reassessed the whole time.
And in fact, when the first interview took place, I believe at the beginning of that interview, you remind Agent Seacrest that you and Mr. Bryan have placed limits on that interview. You're not going to talk about the homicide itself. You're only talking about what took place afterwards. Do you recall that? Okay. And those were your limits and Mr. Bryan's limits in order to get comfortable with Agent Seacrest?
First, get comfortable, but also to limit the liability, the downside of the interview. When Mr. Bryan is talking about conduct after the shooting forward, which in retrospect seems odd, but there was a lot of controversy around the video at the time, including its authenticity and where it came from. And that was the heart of the GBI's case, and they needed Mr. Bryan's cooperation to get that. It didn't have to have it, but it would make it easier.
And when you mentioned that there were things, meaning other information that you could offer the GBI, you mentioned his Night Owl video,
yes,
which unfortunately the Glenn County Police Department had never asked him about or obtained, but he revealed, I have this video. And at that point, Special Agent Lawrence Kelly was able to go retrieve the Night Owl video from Mr. Bryan's home service.
I think that actually happened on the 13th, but I could be wrong.
I think you're right, it was on the 13th. So, but that's some of the things that you were willing to do to show cooperation?
Show good faith, anyway. It's important to remember that the goal at this point was that the GBI recognized Mr. Bryan publicly as a witness rather than a target of their investigation, to kind of take that target off his back, not just in terms of law enforcement, but in terms of being killed before this case could go to trial. So that was important. And he had been very helpful, whether he intended to or not, by making the video on the day of the shooting. And he had been pretty cooperative that day on the side of the road and at the police station. For better or for worse, he made the decision to cooperate with the police before he had counsel.
Do you want to see how much money you're eligible for? If you were in a car crash within the last 2 years.
Hold on, I don't know why it's doing that now.
Complicated his situation was because he'd already made that decision and started down that road. Does he want to continue down that road or go the other way? He did have information like the Night Owl video, and there were a couple other items of evidence or testimony that the police did not have. There were some statements that Mr. Bryan overheard Greg and or Travis make in the aftermath of the shooting that were not on the video that he made, that the police wouldn't have in any other way.
In addition, was Mr. Bryan able to then reveal how Greg McMichael obtained the video from his cell phone in order to hand it over to the media?
I don't recall the details, but yes, there were things that GBI wanted from Mr. Bryan, and you know, the idea that Mr. Bryan is knocking down the door of the GBI office to volunteer information is a bit of an overstatement. But he'd already made the decision to cooperate on the day of the shooting. And that had a big impact on how to go forward, because he had already made statements and there was no taking them back.
So the goal with these interviews, because the GBIs requested the interviews, your choice then was to not participate or to continue to cooperate. And the choice to continue to cooperate, is it fair to say that's the hope that he never is arrested and then becomes a witness for the GBI and or the prosecution?
Right. When we talk about deals, there was never a discussion of a plea. It was a discussion of being prosecuted or not. There was never a notion of immunity at that time, because it was not, it just not something that was realistic at that stage. No prosecutor in America, much less your office, is going to grant immunity in a case that high profile when there's so many loose ends out there. The goal was to be a subject rather than a target, and a witness rather than a defendant.
So I just want to be kind of clear about this. And I know it's been 3 years. So if you recall, I think you did file a Jackson-Deno motion. We never had the Jackson-Deno hearing because he was represented by counsel and was not under arrest at the time of Agent Seacrest. So would it be fair to say that your memory of this interaction and cross-examination of Seacrest was actually during trial?
It may have been during the trial.
Okay. And do you remember you cross-examined him for a couple hours during trial?
I'm sure that I had more than a few questions for Agent Seacrest.
Okay. All right. So when we talk about doing the second interview on the 13th, May 13th, I believe, you correct me if I'm wrong, that when you met first with Agent Seacrest, you set the parameters of Mr. Bryan is going to talk to you only about what took place afterward. And if we're comfortable, meaning if we trust you and Mr. Bryan's comfortable with going forward, he makes that decision, then we'll do a second interview. Was that done to kind of show good faith on Mr. Bryan's part and to hopefully keep the GBI strung along?
Well, the first interview certainly was to show good faith. Among other things, the GBI had to assess whether Roddy would be useful as a witness. And there, early on, there were some questions as to, you know, some people just aren't good witnesses. It's got nothing to do with what they know. It's got nothing to do with the truth. It's just got to do with the the personality of the person. And now I forgot the rest of what you asked me.
Was it also an attempt to maybe string the GBI along to buy more time and forestall potentially what could happen, which would be an arrest?
You forgot what she asked.
Buying time was important.
Because you were BS.
We were well behind the game. The GBI had, I can't even remember how many agents were down here. And you had just a lot of activity going on. So yeah, we needed more time. I would have wanted more time. I did everything I could think of to buy more time. But ultimately a decision had to be made whether to go back and on the 13th or not.
And did you discuss with Mr. Bryan his decision to go ahead and go forward with that second interview?
Yes.
And did you also discuss the fact that you were going to talk about what actually happened at the homicide at that time?
Yes.
I think you previously testified that you were there to do the right thing and hope for the best. And because at that point, you know, the prosecutors were not involved in any decision. And so what you were hoping for was, I'm gonna let you finish my sentence for me.
That Roddy would be identified as a subject, not a target, as a witness, not a defendant. That's the best. It's the best we were going to get under the circumstances.
And he voluntarily turned himself in.
He did.
And at that point in time, you were retained to go ahead and represent him at trial.
Yes.
Okay. And I'm not going to belabor the entire trial experience, but you filed numerous motions. Is that correct?
Oh, yes.
Okay.
Yes.
And you filed motions to recuse the district attorney's office along with discovery motions, and you received the discovery packet. Is that correct?
Yes.
and reviewed all of that evidence
Yes.
and prepared cross-examination of the witnesses.
Yes.
Put in place a ban on the importation of assault weapons into our country.
Defeat confiscation Kamala.
And talked to Mr. O'Brien about his decision to either testify or not testify.
Yes.
And I take it that you felt, and correct me if I'm wrong, but that because he had made the statements to the GBI and had gotten his sort of softer version of the events that took place on February 23rd, 2020, that your advice to him, but it's his decision, might have been to not testify since he didn't necessarily need to, given his statements were already in evidence.
That's correct.
But it's not your job to tell him what to do or not, right?
It's not my job to tell him, and it was emphatically clear that he did not want to testify at that time, after watching the way witnesses were treated during the trial.
And so when you talked about the fact that you knew it was a risk to go and be interviewed, have Mr. Bryan interviewed by the GBI, it was a strategic decision to go ahead and embrace that risk with the hope that he'd be identified as a subject and not a target and not arrested.
Yes, that was a calculated risk.
All right, let's go ahead and move on to the mistake of fact jury charge.
Yep.
All right, so the state, me, wanted the pattern jury charge. Is that correct?
You always want the pattern jury charge. Every prosecutor does.
We all do. So in this case, the trial court did give the jury the pattern jury charge of mistake of fact for them to consider.
The court did.
All right. And they had a copy of that jury charge back with them. Is that correct?
Yes.
Okay. Now, I get that you had previously, or you just testified that it was not a strategic decision to leave out the mistake of fact argument, but a blunder on your part. But I want to kind of talk to you about what took place that day. The state gave an hour-long opening closing argument, and then the McMichaels gave, not the McMichaels, Travis McMichael's counsel gave the closing argument, and then Laura Hogue gave Greg McMichael's closing argument, and then we got to about 3 o'clock in the afternoon, and it was your turn. Does that sound fair? And you gave an hour and 40-minute long closing argument.
Yeah, I think co-counsel were disappointed. Well, I think the hope was that the defense closings, and I had help along the way. I wasn't the only person that took some time, but I think the hope was that the defense closings would finish in time to force you to give your closing the same day and not get the benefit of the evening to parse through everything that had gone on during the day. It's, aside from going last, it's a considerable advantage for the prosecution when you can get a recess overnight. And it's unfortunate. On the other hand, I'm not sure how much time I could have taken where you wouldn't have gotten the evening anyway.
And you had a lot to cover with regard to Mr. Bryan, as far as a lot of the legal issues.
In some ways, Mr. Bryan had more legal issues than the other defendants.
And of course, they hadn't covered them yet.
Well, no.
Okay. So with the McMichaels closing arguments, they basically had to cover citizen's arrest, self-defense, and what took place that day, as well as reiterate Travis's trial testimony. Be fair to say?
Yes.
But you had to do something different because your client was in a different position.
He was in a very different position.
Okay. And that was your argument, that he had no knowledge that Travis had the shotgun.
That's correct.
Okay. And I believe at the very end, you wrapped up by saying, when would Mr. Bryan have been able to stop this from happening?
Yes.
Okay. Now, I think you testified that as of right now, when you sit here 3 years later, you can't really recall what the mistake of fact would have been. But you're very, very smart, Mr. Goff, and you're a very, very good attorney. I mean, right now, what would have been the mistake of fact argument under these facts?
I'm sure it would have been very good, but to be fair, I can't recall exactly what it would have been because that part was not written down. There were several parts of the closing that were not written down. Just run out of time, and say something about this, say something about that. To be fair, going back through the motions, there's some motions I filed looking back today. There was a reason for them at the time, but it takes some time to piece it together. But I can't identify for you what that fact would be.
All right, so I'm just going to throw this out there. When we look at the jury charge of mistake of fact, it's an affirmative defense, correct?
It is.
And it's an affirmative defense where basically the defendant is charged with a crime, but says, I'm not guilty. I didn't have any intent to commit this crime because I had facts that, if true, would have enabled me to go ahead and do what I did. I'll give you an example. If I have my friend Cindy tell me that my friend Leslie is allowing me to use her credit card, and I go to the store and buy a whole bunch of stuff, am I intending to steal from Leslie because I'm using your credit card? Well, I'm operating under the mistake of fact that my friend Cindy has told me, oh, Leslie's okay with you using the credit card. And that's my defense. No intent to commit theft. I was under a mistake of fact because I was given information by someone else, correct?
Yes.
Okay. Did we have anything that resembled that in this case?
Well, Mr. Zell won't tell me, but he obviously feels he's got a pretty good one. But he doesn't have to share it with me. Mistake of fact is a problematic defense because it depends on the underlying offenses. Some offenses lend themselves more to it than others. But again, I did not consciously make a decision not to present that. As you could see from what was presented, I did deliberately leave out small snippets here and there. As the trial went along, they weren't as important. But mistake of fact is something that should have been argued, and it'll be for you and Mr. Zell and Judge Walmsley and the appellate courts to figure out what to do about that. But I'm not sure what more I can tell you.
I guess that's where I have a problem, is that you say it should have been argued. But if right at this point in time, no one can say how it should have been argued or what context it would have been argued in, because you'd agree that the state, in its first closing argument, got up and actually said, this case is all about assumptions and driveway decisions. And we all know you can't make an assumption and then claim mistake of fact. So are you certain you didn't pivot and go, I'm not going to argue that, given the state just got up here and argued that my client made an assumption? If I say mistake of fact, I'm actually saying his mistake of fact is an assumption, which would have played right into my closing argument?
My recollection 3 years later is that was simply a mistake. For example, sometimes jurors will do what I call squirrel. That's a phrase we used to use in the debate world when I was a college student, where the judge would just go off on something that nobody realized was important. So a lot of times, even if you're not impressed, you're going to at least present the charge to the jury, argue the charge to the jury, say something in the hope that one of the jurors will see something in it that different than you saw, or that you saw but couldn't say. But when you don't discuss the charge, that alone is harmful, because you get back in the jury box, particularly in a case like this, where the jurors have First Amendment rights, and all these jurors probably assume that somebody's going to spill the beans, when the whole thing is over. Who wants to be the juror in this case in the back of the room arguing the mistake of fact that the judge charged to the jury, when somebody else in the jury is going to say, the lawyer didn't even mention it. If the lawyer didn't think it was important, how important could it be? So there is a harm in not covering a charge that actually has potential value. Does that mean that a jury would have found a mistake of fact if I had argued, if I had spent an hour on it? I don't know, but it should have presented it. And
well, in Mr. Zell's motion, he claims it was your sole defense.
Well, that's ridiculous.
Tell us why.
I can't even count the number of defenses that were put out there. And I'm not even sure mistake of fact would be the best of the defenses that were available. You know, part of Roddy's problem in this case was that the citizen arrest law, of course, the citizen arrest law that got to the jury was much different than the one that I learned about. That's a different issue. But putting that issue aside, the law of citizen's arrest for over 100 years is extremely harsh. I mean, that's not what I would have argued at the time of the trial, but the reality is that citizen arrest law is brutal. Even the old citizen arrest law. I mean, if you help somebody arrest somebody, you better be right.
I'm sorry, I don't mean to maybe I should say you misstated what I wrote. I said it was a sole defense. Maybe that alters your question. I said the only viable defense. I do think that's a difference. At least it is in my mind.
Thank you, Mr. Zell. Thank you, because I did, in my mind, I read it as sole defense, but I will go ahead and then, so was it the only viable defense?
Well, you know, jury nullification is always a delicate subject. And a lot of the problem with this case is that in Georgia, what lawyers can say with respect to jury nullification is extremely limited. There's snippets in the pattern charge that you can throw out there. Nobody can tell a jury that they have the right to acquit for any reason or no reason. Nobody can tell them that. The judge can't tell them that. The lawyers can't tell them that. But they can reach that conclusion on their own, and there are snippets in the charges. But the more directly you approach that argument, the more you risk someone coming down very harshly upon you from the bench. So it gets very difficult. But in Roddy's case, under the law, if the McMichaels didn't have probable cause, I don't know whether Roddy can have probable cause. Certainly sitting here 3 years later, I don't know the answer, but I do know that Roddy was a very sympathetic defendant. And the jury had the opportunity, if they chose to do that, to agree that he was just a dummy in the wrong place at the wrong time, and that a few short minutes of bad judgment in his life, completely uncharacteristic, the opposite of his entire life, should destroy it. The jury could have, regardless of the charges, let Mr. Bryan go, which is why the jury selection process was so important in this case. We lost the case of jury selection. We didn't lose it during the course of the trial with you.
But you made those arguments in your closing, didn't you?
I came up with every way that I could think of under the law, consistent with the charge of the court and my duty as an officer of the court, to get someone, at least one person on the jury, to give Mr. Bryan the benefit of the doubt. I argued it every different which way I could. But what I didn't do is I didn't argue mistake of fact. And I can't get around that. Whether that is harmful error or not, whether that meets the second prong of Strickland or not.
Donald Trump intends to give tax breaks to billionaires.
But I do know what I didn't do. And I will defend, I don't, you know, as an officer of the court, I will defend what I do when it's right. But if I've made a mistake, and there are some mistakes that are just open and obvious, and if you had a charge you intended to argue in a defense that you intended to argue and you didn't, your duty is to say so. It's not my duty to figure out whether that matters or not. That's between you and Mr. Zell. But that was not a strategic decision. And if I had it to do over again, I don't know whether I would have put a special colored paper clip on it or why, because that closing had, I mean, a couple inches worth of materials to work from, and it was unfortunate that it got misplaced.
And the jury came back not guilty on several charges, didn't they?
Yes, and they probably felt that they were doing Mr. Bryan a big favor because he really didn't understand the law, particularly the law of felony murder. But I have no doubt that when they were back there, they thought they had cut Mr. Bryan a significant break. I doubt that any of them appreciated that he was going to receive a mandatory life sentence as a result. But under Georgia law, we are not allowed to discuss sentencing in front of the jury. And I have no doubt that if there had been any explicit attempt to address that subject, however indirectly, that would have been shut down in a heartbeat.
Indeed. I may have one moment, Your Honor. I will pass the witness. Thank you, Judge.
Mr. Zell, whenever you're ready.
No further questions, especially since Mr. Stomikowski was the one in the charge conference who asked for the charge and said he has every right to argue it. I'm surprised he didn't ask for it. So, no, I have no more questions.
Thank you, Mr. Coffey. Step down.
If I may inquire, Your Honor, some other advocates in the case, am I excused or should I go back to the witness?
Is he under subpoena?
Yes, he is, Your Honor.
Okay. Is he released or does he need to remain?
We probably need to call him as a witness and, excuse me,
It's okay. I think that.
Yeah, I'm
I'm
sorry.
inside today. I'll be outside.
Okay. Thank you, Mr. All right. It's probably a good time to take a break for lunch. So let's go ahead and take an hour. It is 1:24. Let's plan on reconvening at 2:30 and go to recess. Thank you, everybody.
All right, guys, we're going to take a 1-minute commercial break and we're going to be right back before faster than their recess. Thank you for being with us tonight. Are you enjoying the broadcast? I know I'm down there talking a lot of stuff, but this is very amazing. Do you hear what the lawyer is saying? Okay. He said that he forgot to argue a mistaken of fact. And this is one of their reasons, one of the next motions to basically get this retrial based on what this lawyer is saying and saying that they possibly offer him a deal. It was a non-deal deal. That's why I kept putting it on the screen. But we'll be back in less than 1 minute.
The real estate market often seems like a distant world where only an elite of experts is successful. In a time of so much uncertainty in the air and bad news, realist investing can seem intimidating. But today, I want to tell you that if you make the right decision today, you can enter the real estate market from the back door. Bad credit record? No credit at all? Do you dread the idea of having a home loan? Do you dream of owning investment properties? You are in the right place and right time because we have created a program which is a tax lien and deed investment online course of only 14 hours. This course is specially designed for people like you who have big dreams. You will learn at your own pace and everything from your home computer. This is your chance. Join our membership for $19.99 a year. What are you waiting for? Visit our website primetimehomebuyerBuyback.org and sign up today for course access.
It was just to go find out. And if you read the transcript, you'll find that he didn't get into what was in discussions in the jury room. But he does put there are some things that pertain to external influences, such as some jurors looked out the window of the jury room and observed paramilitary people in paramilitary garb with automatic style weapons. And that we would submit as a potential external influence that the juror is looking at, and there are people in the demonstration carrying an AR-15.
Judge, at this point, I apologize for interrupting Mr. Donaldson. I have to object. I've read these transcripts. Lee Wilson asked these jurors, did you see anybody out there with a gun? Nobody said paramilitary style. Nobody said AR-15. Nobody said any of that. And I'm concerned that now it's being completely misconstrued as to what's actually in these transcripts. And my other concern is if this is for impeachment of the jurors when they testify under 613, I get that, but then use it as impeachment. Don't try and tender it into evidence and then put the juror up. I mean, we're kind of getting the cart before the horse there if it's 613 we're talking about. So the state's position is let's just put the jurors up, Your Honor.
This has not been discussed for an extended period of time. I've indicated the witnesses that you wish to call, who are available, can be called under the limitations that I have already that I outlined this morning. I've made specific a ruling as I can on 3 issues.
I still will proffer. Excuse me, my legs are very weak and I'm a little bit unsteady right now. We still will proffer. We'll ask the court to take these transcripts into the record. They may be totally inadmissible, in which event the court will make its ruling, but we still want them in the record as being not considered. We're not dealing with the jury here. We're dealing with what this court should and should not consider in ruling on a motion for new trial. So my plan is to put Mr. Wilson up and have him it's a proffer. And
So you want to make a proffer of a bunch of transcripts,
yes, Your Honor,
uncertified, that are in an affidavit?
No, they're not in affidavit.
I was just trying to see if I could help. I'm not sure who's responsible was properly the issues the judge said that you cannot give, Your Honor said you cannot get into, as opposed to the other matters. So because you can question the jurors on that. Is that correct, Mr. Thompson? You just want to get into these other matters to the matters for which Judge Wally said you could not pursue with the jurors? I've been in a quandary since May about, I'm sorry, I should address the court, since May about having jurors and the anonymity and the privacy that the court was affording to the juror.
And let me be clear, that's going to be addressed, and I'm going to direct this to the media and the parties. If we get to the point where we are calling a juror, there shall be no cameras on the juror while they are testifying or while they're in the courtroom in any way. And they will be referred to by their number. The record is very clear on how those numbers can be connected to individuals. I assume everyone will know how to do that. But so there'll be no print or video images of the jurors. And again, we will not be using their names.
So that's exactly what I was soliciting in the way of an order, because I know, these people sat through a high profile and emotional trial and don't need to be exposed to these problems. And juror 580 has been subpoenaed, and she was here earlier, and she said, my understanding is she has announced that she will not come back. And when I talked to her on the telephone yesterday, she said, well, you'll just have to arrest me. And I said, ma'am, I won't be the one arresting you, but if you, and she may come. We've got her on we've told her 30 minutes notice, and she's being called right now. So that's just the announcement. Now, 380 and 79 are here. So, and that's the whole reason I wanted to get some clarity as to where we are.
Mr. Johnson, I've said a number of times, the court is not here to tell you how to do your cases. So let's move into the evidence. If you have witnesses you wish to call or anything else with respect to your motion for new trial,
we'll call Lee Wilson.
Lee Wilson?
Yes. This is anticipated. Mr. Wilson,
well, he's called as a witness. Let's let him get into it. Told you nothing but the truth.
Yes.
I want to make one additional announcement here. I will not ask any questions about about where he can be located. Some of the people involved in the trial of this case received death threats, and I just assume we can give the court the information, his business address and all of that, but I'd rather not put it on the record.
And also, since we just had this conversation, I just want to be clear, the witness was not in the courtroom at the time, and I understand that some of this testimony may address jurors. The jurors are not to be identified by name, only by number.
Yes.
Your witness.
If you would just introduce yourself to the court. Yes, my name is Lee Wilson. That's Leewilson.
And what kind of business do you engage in?
I own and operate a private investigative business.
And how long have you been in that business, that type of work?
Approximately 12 years.
Were you involved in this case, the trial involving the death of Ahmaud Arbery, as in terms of the trial and in terms of preparation for the trial?
I was.
And who retained you in that fashion?
I was retained by the counsel for Travis and Greg McMichael.
And did you in fact investigate?
I did.
Were you here at any time during the trial?
Just about every minute of it. I would step out occasionally, but
after the trial, did you have any contact with jurors who had been deliberating and returned a verdict in the case?
I did.
Can you tell us the purpose of contacting? Well, first of all, did you get to contact all 12 jurors?
I got to contact probably 10. I don't have the statistics, but I did not speak to every one of them.
You did speak to how many?
I believe it was 10 that I actually made contact with.
And of those 10, were they cooperative in terms of, were they all cooperative in terms of talking to you?
No.
Of the 10, were you able to have an interview with some of the jurors?
I did.
And by number, can you tell us who those jurors were?
I can. Juror number 79, juror number 380, and juror number 580.
And have you seen those 3 jurors today?
Yes, I have.
They've been here in the courthouse?
Yes, they have.
And are you aware of any contact that we said that we put them on 30 minutes call, is that correct?
Yes, and I believe 2 have returned.
2 have returned. And you had one juror who, did you have a juror who's not cooperative or says she's not cooperative in terms of returning?
I did.
And which juror is that?
That would be juror number 380.
380?
580.
580. All right. If you interviewed 3 jurors following the trial, is that a normal practice for you?
I've done it a number of times over the years. Not every attorney wants it or needs it. It depends on the verdict and whether it goes, which way it goes. But it's not an uncommon practice. I've probably done it 20 times in my career.
What's your purpose in general? And I know in making or contacting the jurors and interviewing them. What purpose?
The purpose is generally to determine what we could have done different, better, try to learn from the experience and try to make the attorneys, and even if it helps me in my investigation, learn more on what we maybe should have done or could have done.
Are you there to be critical in any fashion of the jurors?
Not at all.
Are you there to try to get the jurors to reconsider their votes?
No, and no. In fact, I tell them that they do not have to cooperate. It's optional.
With respect to the 3 that did speak with you, did you record them?
I did.
And did you tell them that you were recording them?
No.
Is that common in your practice to record and not disclose that they're being recorded?
Much like law enforcement, yes, I do that. I do it daily, as a matter of fact, on witnesses I interview.
Now, have you listened to the audio tapes or audio of those 3 interviews?
Yes.
Do you know whether transcripts were produced with respect to those 3 interviews?
They were.
Have you, may I approach the witness, Your Honor? Yes. I'm going to mark these as Defendant's Exhibit 1. Defendant's Exhibit 2, Defendant's Exhibit 3, and I'll display them to counsel. I'm sorry, I'm kind of feeling late today. Thank you. May I approach the witness? Yes. Ms. Wilson, I'll hand you 3 envelopes with some contents and ask you if you're familiar with the envelopes and the enclosures.
You just go through them one by one?
Yeah.
Okay. The first one is a white manila envelope marked Defendant's Exhibit 1. Contained inside is a copy of the transcript of my interview with Juror 79 conducted on July 9th, 2022.
Now, have you compared that transcript with the audio of the interview?
I have.
And can you tell us, there are some places in it where it'll say inaudible and things of that nature, but other than those places where that occurs, and it occurs all the time in transcript, other than those, how does it compare in terms of accuracy relative to the actual audio?
It's exactly what each one of us said during it. It's a fair and accurate depiction of what was said during.
Have you listened to and personally compared those the transcripts to the audios?
I
have. With respect to Exhibit 1, that's Juror 79. Is that correct?
That's
I
correct.
don't need to pull it out.
That's correct.
All right. Is that transcript accurate in terms of the content of the audio?
Yes.
All right. Now, could you go to Exhibit 2?
Exhibit 2 is a white manila envelope containing a transcript of a interview that I conducted with Juror 380 on June 25th, 2022.
Have you had occasion to have conversation with Juror 380 recently?
Last week.
And if we place it in, I'll ask the same questions in terms of identifying it. Have you listened to the audio tape of, I don't know whether it's a tape, have you listened to the audio of the interview of Juror 380?
Yes, sir.
And how does it compare to the content of the transcript?
It's a fair and accurate depiction of the conversation I had with Juror 380.
Right. And if you'll go to Exhibit number 3.
A white manila envelope marked Defendant's Exhibit 3 containing a transcript of an interview with Juror 580 that I conducted also on June 25th of 2022.
And the same questions. Have you compared that transcript to the audio of the interview?
I did.
And how does it compare?
It's a fair and accurate depiction of the conversation I had with Juror 580 on that day.
One more authenticating question. With respect to each of those, can you tell us whether the audios tapes, whatever it was, a tape or some, I don't know what the right word is, the audios, do you know how they compare to the actual interview that you had with those three jurors?
All interviews were digitally recorded and then uploaded to my company server where they were marked and identified and saved in a client vault. I have a database that I use for client sensitive information. And I've downloaded those interviews and compared them with the transcripts in preparation of this hearing.
Donna, we'll tender or proffer exhibits 1, 2, and 3 for the record. Defendants exhibits 1, 2, and 3 for the record.
Well, the state's going to object. Number one, their hearsay, and number two, the relevance. And I understand that Mr. Donaldson said he's proffering them.
Well, I understand the objection is relevance and hearsay.
Yes,
That's
Judge.
sustained.
It is sustained.
Sustained.
All right. We proffer them to just be included in the record. I understand the court's not going to consider them, but in this case, and I assume, and I don't mean any disrespect to the court, but motions like this don't get.
I'm not going to allow the tender of them right now to the record. I'll take it under advisement and I'll consider it. I understand that's a request to make it part of the record or make them part of the record.
Yes, and
Mr. Donaldson, let me finish.
Under seal.
Well, I haven't sealed them. The problem is they're not under seal. And the moment they come into the record is they become a public record. You are dancing on the head of a pin under Rule 606 here. And I am concerned on a number of levels about what is trying to be accomplished by tendering these in just simply to the record. They are not relevant and they are hearsay. So they are not evidence in this court. So at this point, I will take that request under advisement and we can move on.
Thank you, Your Honor. And with respect to the hearsay objection, we're not offering them to prove the truth of the matter of the statements of the jurors. We're offering them so that it's not hearsay. It's only hearsay if we're trying to prove that what these jurors said is truthful. We're offering them just to have the evidence to say that this is what they said, prior statements, and that's the purpose of it. The relevance, of course, is left to the court's discretion.
Court's ruled.
All right, understand. Your Honor, in terms of the proffer, that's what I offer. That's all I wanted to offer, is just to get them in the record. Mr. Lamar, at a later point, will examine Mr. Wilson concerning other matters not related to these transcripts. So I'll pass the witness to Ms. Donikowski on that, and we will probably recall Mr. Wilson to testify to other matters, not hearsay, but relevant and having to do with his
Why
observation.
aren't we completing the witness?
Pardon?
Why aren't we completing the witness?
Well, I can certainly do that.
He's on the stand. He's under oath.
All right, well, I'll do that. I do want to get the issue of proffer in terms of the transcript, in terms of the record. I do want to put it together, so if I could pass to Ms. Donikowski on that issue, and then I'll address the others.
I may be mistaken, but I understand the state simply objected and that has been sustained. So I don't believe there's no, unless I'm wrong, and I don't think I'm misunderstanding where we are procedurally, the state's already put its position on the record and the court's ruled.
I understand, but I thought perhaps you would want to cross-examine.
We've gone over this a number of times.
All right, John, I'll do the remainder of the examination. Let me get those exhibits. moment, I need to display these exhibits to the state before I try to examine them.
Okay.
Yeah, that's not one. We just want to establish the atmosphere of trial. One of those forms of packet for you. Just in front of you, go ahead and number the sequence. Top one will be 4, and then 5, 6, and 7. All right, thank you. I'm sorry, I'm a little bit feeble, Your Honor, and not moving well, but
We could just assist him with getting documents up to the witness.
yeah, I'm just going to put the numbers in the court. For the court, I'll hand courtesy copies of these documents to the court, and I should note in sequence, they'll be numbering, starting with number 4. And I'll do that here, and the court will know what I'm looking at. I've given the same to Ms. Jonikowski. If I can sit down and number.
Yeah, in fact, you can feel free to take a seat, and if that microphone reaches down, however you need to do it, sir.
Yes, Sean, I'm not asking for sympathy. I should have pre-marked them, and I apologize, Your Honor, for not doing so.
During the trial, that I was moving.
Hold on, y'all. Y'all know this man was trying to submit some evidence right there. He was actually labeling it. I don't want to miss anything. This is ridiculous. Let's finish watch.
So that's all in the transcript.
And there's absolutely no enumeration of error pertaining to what was going on outside the courthouse.
May it please the court, my response is that we believe that the jurors, or some of the jurors, were exposed through the window to what was going on outside the courthouse. And there is, in the transcript, there is some reference to that as an external influence. They're looking out, seeing armed people. And again, it's not juror misconduct, but it's external contact. And I just simply wanted to illustrate the atmosphere around the courthouse.
Well, Mr. Chappell's already touched on this already. The transcript is full of references to exactly what was happening around the courthouse in real time, primarily thanks to Mr. Goff during the trial of this case. After lunch, at least for the first couple of days of trial, and then from there. And then also, at least with respect to the jury, as you have mentioned, it is referenced in the trial transcript. And in fact, the court announced to the parties during the trial that I was moving the jury. So that's all in the transcript. So as far as what his observations were, you were going to need to get more than that. So that's sustained.
If I might respond, these are just graphic representations of things that are in the record. And yes, the court did move the jury for the announced reason that you couldn't make out what they were saying, but they were hearing sounds.
I sustain the objection to the question. You have some pictures. Now, if they have some relevance, then you can go ahead and get into that. But again, that question, objection is sustained.
Have you looked at the photographs that have been handed to you?
I have.
Take the last one out because it's a little bit different and unrelated to the specific line of inquiry. Can you tell us the numbers on the exhibits that you are looking at?
Get it back in order. Exhibit number 5.
I don't want you to describe them because we'll talk about that in a minute. Just what are the numbers on the exhibit?
Exhibit 5, exhibit number 6, 7, that one's 4, 10, 11, 12, 13, 14, 15, 16, and 17, and 18.
Now, and again, we don't need to get deep into each one. You just generically describe what those exhibits 4 through 18, what they display.
In general, they display activities taking place on the perimeter of the courthouse, primarily during the last 3 days of the trial, which including the closing arguments, the jury charge, and the deliberations.
And do you make, or have you made observations yourself as to what was going on outside the courthouse?
I did.
Just tell us in general what you saw.
Objection, relevant.
Yeah, no, I understand and anticipated that. I just had the same response. And again, we believe, and the court's indicated that it's replete in the record. And I suppose, repetition or something of that nature, but we believe that what went on outside the courthouse is relevant because jurors were exposed to it. Now, I understand, I know I'm a little bit cart before the horse, and that really is the purpose, is to, when these jurors testify, I will ask them questions not about these photographs, but what they saw, in fact, Mr. Lamar will be doing the direct examination on that, but that's the purpose of all of this. It's to lay, I don't want to say a foundation, it's to lay the groundwork for the examination of the jurors. And that's the purpose. We tender them. They understand the objection, and I suspect the court will sustain it.
And I'm going to sustain it. I'm not suggesting that the argument's not there. I've told the parties that You know, if extraneous information was there, then the court needs to know about it. But the record is replete with what was going on around the courthouse, and I have not heard anything specifically about what may have been extraneous to the panel, and so it's sustained.
They're tendered, and
the objection was sustained.
yes, sir. If you would look at exhibit number 19. Can you tell us what that is? What that is,
Yes, exhibit 19 is a picture from the interior of the courtroom. Much from where I'm in the area where I'm sitting now, shooting backwards.
You know why that, you know the relevance of that photograph with regard to the issues that are before the court?
I do.
Can you explain that to the court?
The state's table during the trial had been turned. We'd set up the courtroom the Friday before jury selection, where it's much like it is today. And when we returned,
Objection, once again, relevance.
Again, it is sustained.
Please, court, one of the issues in the motion for new trial, the amended motion for new trial, is the connection between the prosecution and the jury. And we offer exhibit 19 solely to illustrate where the table was, the prosecution table, in relation to the jury. And we believe that's relevant for that purpose, and I've tendered it for that purpose.
Your Honor, I'm confused, but I will try and clarify. It appears that in enumeration of error number 6 of Travis and Greg McMichael's amended motion for new trial, they claim that one of the jurors could read my mind and my facial expressions, and that therefore there was prejudicial communication, not intentional by me, which I appreciate, but that unintentionally, because my facial expressions were seen by the jurors, that I somehow demeaned the defense attorneys during trial, and that this is for error. And I didn't have you mention, I noticed you didn't mention that as one of the grounds for the jurors to be covering. So I didn't know if you were anticipating having testimony as to that juror and her thoughts about my facial expressions, because that goes into the thoughts and minds of the juror, and it is outside of Rule 606, because defense counsel is not alleging I was doing it on purpose to communicate extraneous prejudicial information. Number one, it wasn't extraneous. I was in the courtroom. And number two, everyone could see it. This photo, number 17, the state and the court all understand that we had 4 alternate jurors. And 3 of those alternate jurors were seated behind the state's table. And the reason for that is because we had all the jurors in the box and 3 of them sat behind. There's a partition so that the audience members and the jurors were separated. And of course, the defense didn't want the jurors, and no one wanted the jurors, to be able to see what was on the state's table. I understand that Mr. Donaldson wants to put this picture in just to, I guess, bolster the fact that our table was on an angle, but I'm pretty sure everybody knows that.
Well, let's do this. I misunderstood which photograph we're talking about. So, yeah, I'm going to permit that. I mean, that's admitted.
It's just illustrative of the point. I want to address what may be a problem. Had you had contact today with Juror 580?
I did by phone just a few minutes ago.
What did she indicate when she was here and left earlier?
I'm going to object to hearsay.
What she said
I don't know whether she'll be here or not.
well, if she's under subpoena and she does not appear when called, then she's not here. What she said to the investigator is that's hearsay.
Let me check with Mr. Lamar. That may be all I have for this witness. Mr. Lamar was going to examine, our plan was to examine Mr. Goff, again concerning the atmosphere and the goings on around the courthouse. I understand that the court has essentially taken notice of it and that anything would be cumulative and not particularly, doesn't add anything to where we are. And if I understand the court's ruling, there wouldn't be no necessity to call Mr. Goff back to the witness stand. I just want to make sure that the court has established for the record that there were various things going on, that there was a crowd, that it was an atmosphere of people outside demonstrating and protesting. And if that's in the record, and I submit that it is, but I want to make sure that the court is acknowledging that. And if that's the case, we won't call Mr. Goff.
Sure, I find it very dangerous to say, yes, I acknowledge that. What I will say again is the record is replete with references to what was going on around the courthouse. The issue is, to me, the question is not whether or not there was or was not something going on around the courthouse. The question I think you're trying to get to is whether or not the jury was exposed to extraneous information.
Absolutely. That's what we're trying to do and establish that. And
those are two completely different things. So again, I have said over and over again, Mr. Chappell first said, I recognize the record has all of those references in there. Mr. Goff, I think, put a great deal of effort during the trial into making sure that it was very clear to everybody that this was not a trial that was going on in a vacuum outside.
Understand, the court has, I assume, in the record, because they were sealed. At one point, Mr. Goff made a motion regarding, he made the motion many times, but toward the very end of the case, he took photographs from the balcony outside of the crowd, and he tendered them in connection with his motion, and they were tendered under seal. And I would ask that those photographs, as he described them, be considered part of the record for this hearing.
I have no memory or recollection of that.
I can find it in the transcript.
I would have to wait for a response from the state and hear from the other parties. I'm not sure what we're doing because, again, what the court would be very open to at this point is evidence, if there is any evidence of the jurors' exposure to extraneous information, if it even occurred, because that's the threshold question.
The state agrees, and we haven't gotten to the threshold question yet. So,
I understand that I have approached this backwards, and the reason for that is to rather than have the juror testify and then bring the photographs and things of that nature, I wanted to establish what was out there. It may or may not be relevant based on what the jurors testified to, and that's the purpose of it. I apologize to the court if I've done it in reverse, but it just seemed the more logical way to approach it. And I think I'll pass the witness at this point.
Any questions for the witness from the state?
Yes, Judge. All right, Mr. Wilson, taking a look at defendant's exhibit number 19.
Is that the one with you in it?
Correct. We're looking at defense exhibit number 19. And this is a screenshot from 11 Alive News. Is that right?
Yes, ma'am.
Okay. And it's of this courtroom.
It appears to be, yes. Yep.
And is that Jason Sheffield standing at the podium that I'm standing at right now?
It is.
And does it depict the screen that was put up between the pews where the audience could sit in order to separate the Arbery family and the McMichael family and the press from three of our jurors who were seated directly behind the state's table?
Yes.
And those three jurors sat behind the state's table, spread out, because it was in the time of COVID and people were still masked up. And the table was moved on an angle by agreement with all parties so that the jurors would not be able to see the state's computers or the state's documents. Is that correct?
It was moved. I'm not familiar with an agreement, and I've spoken.
Well, don't go into anything anyone said, because we don't want to go into hearsay.
I'm unaware of any agreement.
So you're unaware that Travis McMichael's trial team and Greg McMichael's trial team and Mr. Goff all knew and wanted this table on an angle that the state was at so that the jurors would not be able to see anything at the state's table, because that would be a problem then. You're unaware of that?
I'm unaware of that.
But you are actually very aware of the seating arrangements within this courtroom and the partition that separated the jurors from the other people who are watching.
Yes, because I sat on the second level. I couldn't see their computers, but.
So you were seated primarily on the second row, because as we have today, we have sheriff's deputies who are seated on the first row. Is that correct?
That's correct.
I'll pass the witness.
Any redirect?
No further questions, Your Honor.
Thank you, sir. You may step down.
Yes.
They were called juror 380.
And Your Honor, we are going to ask that the rule of sequestration still be imposed if for some reason I'm assuming juror 380 says something different than what's in whatever these alleged transcripts say. They're going to want to put Mr. Wilson back up.
For impeachment purposes.
Yes.
Yeah, the rule's still in vogue then.
Thank you, Judge.
That's juror 380. I'll turn up.
Yeah, we can do audio. That's fine, but the camera's off. Or you can, that's fine. Do I tell the truth, whole truth, and nothing but the truth? Yes. Go ahead, have a seat, sir.
This is what they're showing. I'm gonna change the picture for you guys.
Let me begin by asking you, were you one of the jurors? And I will not use your name. I will not use your name, but I will use your number. Were you one of the jurors in the trial of involving the death of Ahmaud Arbery.
Yes, sir.
And you were juror 380, 380?
That's correct.
You and I have met before?
Yes.
And that was what, about a week ago?
About a week ago.
And you were subpoenaed, and with your subpoena package, you received a copy of a transcript of an interview. Did you recall that?
Yes.
And did you read that transcript?
Yes.
We spoke after you read the transcript, and you said you wanted to compare it audio, an audio. Is that correct?
Yes.
To see if it was accurate.
I didn't listen to the audio. Didn't have nothing to play it with.
You didn't have anything to play with. You told us that you would need a CD, a compact disc, and we delivered to you what we believe was a compact disc. You recall receiving that?
She delivered a DVD.
All right. So you were not able to compare the transcript to the audio because you didn't have anything to play it on.
No.
So we'll work without that. Excuse me, let me get 380. You're a very deeply religious man, are you not?
Yes, sir.
And you pray daily?
Yes, I do.
And you've described that you pray daily to me.
Yes.
When Mr. Wilson and I came to visit you, I guess it's a little over a week ago. Is that right?
That's right.
And we sat on the porch and talked, and it was a pleasant conversation.
Yes, sir.
We and you talked to me later on the telephone, telling me that the transcript seemed to be scrunched up in terms of, I think you said scrunched up in terms of what was said, and I understood that to mean
right. Some of the things that I explained, he cut it off and went to something else.
Okay. And that's based on your memory?
No, that was in the script.
Okay, it's in the script. You recall being asked by Mr., and this was back in June of 2022. It was about
Objection. Form of question. First off, this witness has not testified to anything, so refreshing his recollection with his prior statement is inappropriate, and the state would object.
I'm simply trying to establish a time frame for the interview. That's, I don't know.
Well, then let's ask him about the interview.
The interview, the transcript says the interview took place June 25, 2022. Is that consistent with your memory?
I believe so, yeah.
You were asked about your feelings about being on the jury, that when you got picked. Is that right?
Right.
And what were your feelings?
Well, I feel all right.
Objection. Relevance. Outside the scope of 606.
Actually, Your Honor, we're not dealing with 606. We're dealing with action. I don't want to say too much in front of the juror, but we're dealing with things that he did and what his attitude and feelings were about being on the jury, as reflected in the transcript.
But you're referring to the most recent transcript, not questions asked during voir dire, correct?
That's correct.
Okay, then that's sustained.
So, you sustained the objection.
I did.
All right. What was your feeling about the family before you were picked to be on the jury?
Well, I felt sorry about what had happened.
Right. And I'm trying to get around the rules concerning examination. And I know I'm going to try not to lead. Can you tell us just generally what was wrong with the transcript? Tell me what in the transcript was not accurate.
Objection relevance.
Sustained.
All right. You, at some point, realized that you were the only African American on the jury.
That's right.
Objection to this line of questioning. This has absolutely nothing to do with the purported issue of lying during voir dire. So I apologize, but I'm going to keep objecting until we get to some relevant evidence.
Is that sustained or?
That standing alone is sustained.
All right. Well, I didn't get all the way through the question. You remember when you came and were first on when they were picking the jury? Do you remember being at this courthouse?
Yes, I remember.
And do you remember being asked the question whether you had any prejudice or bias right on your mind regarding either of the parties? And let me get the right question. You remember that they called you and asked you questions all by yourself?
Yes.
And that was after you had been asked questions, the whole panel were asked questions. You remember that?
Yes.
All right. Do you remember raising your hand and agreeing to tell the truth as you, even before you were questioned individually?
Yes.
And you remember that you, as the panel, all at one time, were asked whether your minds were perfectly clear and that whether you had any prejudice or bias resting on your mind about the parties, about the case.
Objection. Yes. That's a misquotation of the question asked to the juror.
All right, let me get the right question. If I could have a moment, Your Honor. I'll need to sit for a moment and look away. Thank you, Bishop. Can I have a moment? Thank you. Got it. Thanks. I think we can do this. The statutory question is in Official Code of Georgia, annotated section 1512-132. And the question is, you remember they asked everyone all at one time, you all were sitting in a panel, and you were asked whether you had any prejudice or bias for or against either the defense or the prosecution. You remember being asked that question?
Objection.
Do you remember being asked that question?
There's an objection.
I'm objecting because that is not the question that was specifically asked at page 200 of volume.
If I could defer to Ms. Donikowski, if she could read the question at page 200 of volume, I think that's probably
Not a problem.
one or
Your Honor.
two.
I will read the question.
Great.
The question was asked, have you any prejudice or bias resting on your mind either for or against the accused? And that was the same question asked every single day. Thank you.
Do you remember that when you were sitting with the other jurors, that question being asked?
Yes.
And it was one of those situations where if you had prejudice or bias, you were supposed to raise your hand or let the court know. Is that right?
Right.
And you didn't say anything to the court about having any prejudice or bias about the accused.
No.
Right. And do you recall when Mr. Wilson came and interviewed you, you told him that the Lord said that he would guide you. Is that right?
That's right.
And you told him that if the Lord
I'm going to
was...
object. Once again, he has not asked this witness a question in order to impeach him with a prior statement to Mr. Wilson. And I'm just asking for it to be done correctly, for a question to be asked of this juror.
I don't really know how to respond to that, Your Honor. I'll try again. Did you, in your mind, when you were potentially being picked as a juror, you asked the Lord for his assistance?
Yes.
Is that right? And the Lord told you that he would guide you. Is that correct?
That's right.
And at one point you said to the Lord, and this is before you were picked, but after you had been summoned.
Objection leading.
Oh my God.
It's a leading question. I mean, I apologize, Judge, but at this point, he's asking a yes or no question. Did you say all
I
these
will
things?
withdraw the question and rephrase it. What did you say to the Lord?
I asked him that I would go, he lead me and guide me through the whole thing, and he did.
Did you have any feelings about the family? And I've asked you that question, but tell me again.
I felt sorry for the family, and after the court started, I felt sorry for both sides.
Right. When did you tell Mr. Wilson anything about whether you would, well, tell me what your feelings were about helping the family.
I wanted to help for the truth to come out, to know right from wrong. And I learned during my years that right is right and wrong is wrong. No matter how you twist it or turn it, wrong is still wrong.
I understand. You know, I'm having to kind of dance around to get to the things that you and Mr. Wilson talked about. where were you working? You worked for the railroad?
Yes, sir.
And at the time of this trial, you were working in Alabama.
Yeah.
And what was your job with the railroad?
I run a machine.
If you could describe the jury that while I look for the right page in the transcript.
This machine's, when they pull the spike out that hold the rails down and take the rail out, this machine shoot the chemical in each spot where the spike came from. And within seconds after that chemical mix in there, it get hard. So when they nail the track back, it is solid. It is 57.5 inches from one rail to the other. And just like you do in a hinge in a door, that would just do it. Plugs the hole where when they put the rail back in, it hold the rails in place.
Your Honor, obviously I've lost the page I'm looking for, and I don't want to belabor it, but I do need to look for it. And what I've done is I've brought the copy of the motion that does not have my notes in the margin, and so I have to look for it. All right. Did you say anything to the Lord about whether you should help the family?
I was already summoned and I wanted to do the right thing.
Did you say anything about you wanted to help the Arbery family?
Yes, I wanted to bring out the truth. If it did happen, I wanted to bring the truth out.
I understand. When you talked with, and on the record, when you talked with Mr. Wilson, did you say to him, to the Lord, I feel sorry for the family. You want me to help them, then I don't mind doing it. And that was a reference to the Arbery family. Is that right?
Both families, I wanted to bring out the truth.
All right. And when Mr. Wilson asked you, but when you say you felt sorry for the family, did someone talk to you about sitting on the jury? And you said, no, nobody's talked to me about this. Is that right?
No.
And then Mr. Wilson asked you, I didn't quite understand when what you mean felt sorry for the family. And you told him, I felt sorry for the family and everything. That was even before I see the tape, the film and everything. So I talked with the Lord on my way, going to work. And this was before you were actually picked, but after you were summoned. I said, if it's for me to do, then I'll do it to help the family because justice got to be done. Do you remember that?
Yes, I remember that. I have 4 sons. And when something like this happened, if you got a son, then it sort of hit home.
Yes, so I've got
so
2.
Nobody wants that to happen to their family.
And as part of the interview, did you tell Mr. Wilson, the Lord showed me? He set everything up. Anyway, after I prayed, I cried for the family, and it turned to a joy cry, and I didn't even know I was picked yet.
That's right.
And in your approach to this, and when you were when you were questioned as a juror, and I'm not talking about when you were brought in and asked individually, but when they asked the question if you had any prejudice or bias resting on your mind, and you didn't raise your hand, you had already said you wanted to help the Arbery family because justice needed to be done.
I wanted to help all the families. I cried because of the situation that was happening. And back in the old days, the same thing happened. And the fact that the same thing happened today is going on.
So have you talked with anybody besides me and Mr. Wilson concerning your testimony today?
No.
When you read the transcript, and I know you said there were some places crunched together, when you read the transcript, was it accurate when it described your conversation, when it recited your conversation about your feelings before you were put on the jury?
Not quite.
Where is it not accurate?
Well, after I seen the film and everything, when I seen the whole deal, what happened, and that night when I got picked, they asked me if I could make a clear judgment. And I told them, I said, yes. I said, but I got to see. I said, I don't understand what went on, but once I see what happened, then I could judge from there.
Okay.
And
that's a little bit different than what you told Mr. Wilson, isn't it?
Mr. Wilson came and wanted to talk, but he didn't tell me he was recording anything. I talked with him for a few minutes, and that was it.
You recall, you live pretty close to here, don't you?
Yes, sir.
How far from here?
Just about 2 blocks.
And if you stand in the street in front of your house, you can see the courthouse. Is that correct?
That's right.
You can just walk down here in 5 minutes.
Yes.
And during the course of the trial, you could hear what was coming when you were at home. You could hear what was going on around the courthouse.
Not at my house, I didn't.
All right. Well, one day during the weekend, did you come to the courthouse while they were having the demonstrations?
One day I was riding down Norwood Street, and I was going to go get something to eat, and they had a thing set up there. They were selling, I guess, hot dogs and stuff like that. So I stopped and got a hot dog.
And you got a hot dog where they set up some booths or had food trucks, or what
They
was
just
it?
had a big grill.
Had a big grill. And were they just people grilling?
Yes, and people standing around.
All right. And you understood that when you went to get a hot dog, the reason they were there was a rally.
Objection leading.
Tell us whether was there a crowd around the courthouse?
Yes, pretty well.
Pretty good crowd. And it was on a weekend?
I think it was.
Now, on a weekend during the trial?
I think that was just before the trial got started. About a week or so before they got started.
All right. That, did you tell Mr. Wilson it was during the trial?
He didn't ask.
No, the question is, did you tell him it was during the trial?
I don't remember. I just told him.
And you knew after you were summoned to be on the jury, even before you came down here, but you'd been summoned, you knew you didn't need to be involved in conversations about the trial.
I didn't talk to nobody about the trial. I bought a hot dog.
You shouldn't.
Objection.
I didn't know. I did not know.
I just would like Mr. Donaldson to please not talk over the juror while he's answering the question.
It's improper for me, and I apologize.
Just let the witness finish his answers.
Once you were summoned to be on the jury, even before you came down here, you knew you weren't supposed to be talking about the case because you were summoned as a juror.
When I got picked, I was working in Alabama, and I was going back and forth. So when I come home to pay bills, I'm here and there paying bills and back to the house.
Was there any kind of a rally going on when you came?
I didn't pay no attention. Just when I came up to buy the hot dog, I hear what was going on, and I went on about my business.
Yes, sir.
I
And
didn't
did
talk with
you?
anybody.
I'm sorry. Go ahead.
So I didn't talk with nobody. I just bought a hot dog and went on.
Okay. Your belief was it was okay to hear things as long as you didn't talk to people.
Well, when you walking around and paying bills, you're going to hear some of everything.
I'm sorry, explain that, please.
When you walking around and all that going on at particular time, it was a lot of things going on. You couldn't miss it. I mean, if you could hear, you hear all kind of stuff.
And there were speakers, people making speeches at the time. Is that right?
At that time, I heard they were speaking.
And you heard the people making speeches.
Yes.
I think you described it as blah, blah, blah. Is that right?
Yes.
You didn't talk to anybody or tell anybody you were on the jury.
No.
But you heard and listened to people making speeches.
When people stand around talking, they talk. And if you could hear, you're gonna hear everything. It's just like in the church when we fast. You walking around and you could smell all kind of good food. You can't close your nose off. You're gonna still smell it. And the air worked the same way.
So you could hear when you went to get the hot dog down among the demonstrators, you could hear what the people were saying.
Yes.
And they were saying things about Ahmaud Arbery.
Yes.
And it was a rally for Ahmaud Arbery.
I don't know if there was a rally or not, but whenever something like that happened, it affects everybody and people talk.
People talk, but you were careful not to talk.
That's right.
But you heard what was being said.
Yes, sort of.
And you do remember, or do you remember, telling Mr. Wilson that you told the Lord before you were picked for the jury, you told the Lord that if he wanted you to help them, the family, you didn't mind doing it.
That's right.
And you told the Lord, I'll do it to help the family because justice got to be done.
I asked him if he'd lead me through the whole thing. So I had to find out what was going on and go from there. I didn't tell him a lot. I asked him. You can't tell the Lord. You ask him what, and he'll work from there.
Okay. May I have a moment, Your Honor?
Yep.
I'll have it with you, Your Honor.
It's okay.
Thank you, Judge. Sheriff Beatty, how are you?
Doing great.
Thank you for being here. When you were asked during general voir dire on Monday, October 25th of 2021, whether you had any prejudice or bias resting upon your mind for or against the accused. Did you tell the truth when you answered that?
Yes, ma'am.
And I know this was a long time ago, and it was your kind of questioning by all the parties when we were in this room. But do you remember telling us that you had actually seen a rally at some point before the trial started?
Yes.
Okay. And do you remember, there was something about going to the hardware store. Do you remember that?
Yes, right
Oh.
over here.
Right over here, right. Now, was the day that you saw the rally when you went to the hardware store the same day that you went and got the hot dog?
Yes.
Okay, so that was all the same day.
Right.
Okay, so on October 25th, and I'm referring so that you guys know, I'm on the October 25th transcript, volume number 9, pages 2132. I believe you were talking with Mr. Rubin, who was Travis McMichael's attorney, and you indicated that you went to the hardware store one day and you heard a commotion.
Yes.
Okay. And you revealed to all of us that you got what you needed to get and you went back home because you knew you'd been summoned.
Right.
Okay. And you explained that that was the hardware store over on Norwich.
Yes.
And he asked you, do you know what kind of rally it was? And you indicated, no, I didn't know what kind, but they had told you that the folks were rallying over about the murder case.
Mm-hmm.
So you were like, I'm not even going to go over there.
That's right.
Okay. And once again, you reiterated, I just got what I came to get and went.
Mm-hmm.
Do you remember that?
That's right.
All right. So now, when investigator Lee Wilson showed up at your house on June 25th, 2022, did he call you and tell you he was going to come?
No.
And in fact, when he showed up, you were on the phone with somebody else, weren't you?
That's right.
Okay. And so he didn't have an appointment,
No.
but you agreed to hang up on your phone call and speak with him.
That's right.
All right. And do you remember him telling you that the reason for the interview was that the defense teams all wanted to try and do things better?
He told me that everyone spoke highly of me and how I prayed with them before they go in the jury room. And so I said, okay, take a seat. I'll be right back.
Okay.
So I went and hung the phone up and came back.
Got it. And did he, well, I think you said he didn't tell you he was recording you, did he?
No, he didn't tell me that.
Okay. And I think at one point you may have said to him, in the context of trying to demonstrate how you weren't out there trying to get information about the trial while you were a juror.
Right.
You indicated that you rode out there one day and they had some stuff set up around the courthouse. They were selling hot dogs and stuff, so I stopped and got a hot dog. They had the speakers set up there and they were steady talking, blah, blah, blah. I just listened, got a hot dog and a drink and kept going.
That's right.
Okay, now was that the same incident date as the hardware rally?
Same date.
Same date. So that had to have happened before the trial started, because obviously you talked about it in jury selection on October 25th, right?
Right.
All right. So you had revealed to the parties about this particular incident.
That's right.
Okay. And I think Mr. Wilson then asked you something like, this was after court or on the weekend or something, and you indicated it was on the weekend.
Yes.
Okay. And then he asked you during the trial. Now, you never said yes or no. I think what you said was, the judge told us we're not supposed to be in a conversation, don't even be involved, so I kept to myself and just did what the Lord said to.
That's right.
All right, so you didn't actually tell Mr. Wilson that this happened during trial, did you?
No.
No, that was him trying to ask you that and you didn't respond. So I'm going to ask you again about your jury questions. Do you also remember telling Mr. Rubin that you'd heard the phrase justice for Ahmaud, and that you said, it means to me if somebody was wrong for killing him, then they need to get the justice and to bring peace to the family and to the neighborhood?
That's right.
Okay. And you told Mr. Rubin that?
Yes.
Mm-hmm. And then I think as we were wrapping up, as you were leaving, and Mr. Rubin was wrapping up his questions, he asked you if you felt any pressure about the effects of being a juror in this case and what it means to you. And you said you didn't.
No, I didn't.
All right. And I think you then said, I pray and ask the Lord to help me to make the right decision.
That's right.
And that's what you told Mr. Rubin on your way out.
Right.
Right. And I hate to ask you this question, but because of the nature, I have to. At any point in time during your voir dire on October 25th, 2021, did you lie to any of us with your answers?
No.
And during that questioning, no one actually asked you how you felt about Ahmaud's family, did they?
No.
Nobody asked you, do you feel sorry for them, or is that sympathy going to get in the way? No one actually asked you these questions, did they?
No.
No. If I may have a moment. I'll pass the witness, Your Honor.
One moment, please, Your Honor, for redirect. I'm sorry. Referring to part of the conversation you had with Mr. Wilson regarding getting a hot dog. You said this is what, it was at page 48 of your interview. This is where Ms. Donikowski was reading to you. Well, let me start to begin with. You didn't go to the hardware store to get a hot dog, did you?
No, I went to get something else, then I went to get the hot dog.
And you went back to where they were having the rally?
I didn't went back there, I just went there. I was
You
hungry.
went to where they were having the rally.
Yeah, instead of, I wanted to go to McDonald's, but that was a little bit further, so that was close right there, so I just ran over
Understand. And you just listened. You didn't talk when you heard the speakers.
Mm-hmm.
Is that right?
Right.
And when you go back to page 48 of the transcript of your interview, when he asked you when you went and got the hot dog, was it during the trial? And you had said it was on a weekend, but it was on a weekend, and he asked you, was it during the trial? Is that right?
I don't remember.
I believe she just read that to you. And she pointed out that you didn't answer that, but you said something else. Is that right?
It's right.
And what you said was the judge told us we don't supposed to be in a conversation, don't even be involved, so I keep to myself, and I just did what the Lord said. Is that what you said?
Yes.
All right, and so when you went and got the hot dog, the judge had already told you, don't talk to anybody.
I didn't talk to nobody.
I know you didn't, but that's what you had been told when you went to get the hot dog. The judge had already told you that.
How do I ask for a hot dog? How do I order?
Well,
Did I
let me
sell a sign?
I'm sorry, I messed that up. Go ahead.
How do I give a sign of what I want? I got an
No,
order.
No, I know that you ordered the hot dog and maybe mustard or chili or whatever went on it, right?
That's right.
All right, and those were words that had nothing to do with the death of Ahmaud Arbery. Is that right?
Right.
You can order a hot dog without talking about it.
That's right.
All right. But when you got the hot dog, it was after the judge had told you, we don't supposed to be in a conversation. Don't even be involved. So I keep to myself, and I just did what the Lord said to do. Is that right?
That's right.
Okay, and that was after the judge had told you that. Had told all of you that, not to be.
Objection to the confusing nature of that question.
I'll unconfuse it. What I'm trying to establish, Mr. 380, I almost said your name, and I apologize for that. What the judge, what in the voir dire, or voir dire, however, it depends on where you live and how you say it. When Mr. Rubin, and you told Mr. Rubin, who was Travis McMichael's attorney, and you told him about going to the hardware store.
Right.
That was before you were picked to be on the jury. Is that right? Because
I believe it was before.
That's right. And you had already been summoned, so you knew that you weren't supposed to talk about what was going on.
I did not talk about what was going on.
Mr. 380, I absolutely believe you did not talk about it. I think that's exactly right.
Right.
But it was before the trial began because you knew you might be on the jury, so you didn't go to the rally. You didn't hear. You just asked what was the sound. They told you it was a rally. Is that right?
While I was at the hardware store.
Yes, sir.
People standing out there talking. When I came out, when I went, I seen them selling. I said, I'm gonna get me a hot dog instead of going to McDonald's. So when I went in, bought what I had to do, and come out, I walked straight over there. And when I got over there, when I really found out what was going on, I just got my hot dog and went back home.
And that was before the trial ever started. Is that right?
I believe it was.
It was. And that was before you had ever seen the judge.
I seen the judge tonight when we got summoned, when we got picked.
All right, it was before you got picked. It was before you even came to the courthouse about this. You had just been summoned when you went to the hardware store and you heard the rally and they told you it was a rally and you knew you didn't need to get involved, so you went home. And maybe you got a hot dog. Is that right?
No, I got a hot dog and went home.
My point, and I'm really just trying to put it in a time frame, that was before you had been picked on the jury.
I think I had already got picked.
You remember, and you told Mr. Rubin, and it's in the record, that it was before you had been picked.
Okay, I remember correctly. Yeah.
Okay.
It was before.
It was before you had been picked. And it was before the judge had ever said a word, or that you heard the judge say a word to anybody.
Now you're trying to get me a little confused.
I know it's confusing. I'm not trying to confuse it, but
I did not talk to nobody. I got a hot dog and went about my business.
I understand that. What I'm trying to do is put time, the date, the time, the rough estimate as to when these two events occurred. Mm-hmm. And you're telling us it was all on one day.
Yes.
Okay.
And where they had it set up, they didn't have it set up around the courthouse. It was on that little strip. It wasn't a block about midways, a little space, but from the hardware store right on that street right there coming to the courthouse. And I just walked right there, got a hot dog, and went back my business.
All right. You told Mr. Rubin that when they were asking you questions, not asking everybody questions, but when they were asking just you questions, that's when you told them about hearing the rally and going to the hardware store.
Right.
Okay. And so that would have been, they weren't asking, if they hadn't started asking you questions yet, then that meant it was before you were picked on the jury, doesn't it?
Right.
Okay. Now, when you went and got the hot dog, you may have gone twice to get a hot dog, I don't know.
No, I went one time.
All right, and that was, and when you were asked the questions, because the judge had talked to you by then, when I say talk to you, talked to the whole jury panel and had told you, and what you said, he asked you, was that during the trial? And you said, the judge told us we don't supposed to be in a conversation, don't even be involved, so I keep to myself, and I just did what the Lord said to, right?
Now, on the transcript, he cut some things off and went to another conversation in the transcript. So
okay,
that's what I told you about. I had marks on.
Okay. But when you talked about getting a hot dog, you also said, I just listened and I went on home because that's what the judge told us. We couldn't be involved, right?
Yes.
Okay, so the first hot dog or the first hardware store was before you were picked. And the second time you went and got a hot dog.
I didn't go back the second time.
All right. The time you went to get a hot dog was after the judge had talked to you.
I need some order in the court, though.
Ma'am?
I need some order in the court.
I didn't know.
I'm just addressing the gallery. I just need some order in the court.
All right. It was, and I apologize, I get loud sometimes, and I'm not trying to be loud. When, on page 48 of your transcript, you talked about getting the hot dog. You heard the speakers talking about at the rally, but you didn't talk to anybody, right?
When I walked.
Yeah, at this point, Judge, asked and answered. This is the 7th time this question's been asked, and at this point in time, all it's achieving is confusion, so I'm objecting.
Well, I readily agree, Your Honor, that it's confusing, and I'm just trying to unconfuse it.
Well, I'm not sure we're getting there. He's answered the question about 4 different times. And we may or may not, or you may or may not agree with his answer, but he has answered it.
When you talk about the transcript, and I think you told me you weren't able to play the CD we gave you, you talk about how things got left out. Is that right?
Right.
But the things that were in it, the things that were recited, the copy, were things that were actually said, weren't they?
Yes.
Okay, thank you. And so we can look at the transcript and know that while there may be some things left out, we also know that what is in the transcript was actually said.
As far as I can see.
And you were pretty careful reading the transcript because you and I talked about it on the telephone.
Yes.
And we talked about it on your front porch a little bit later.
I finished this transcript after we talked on the front porch.
Okay. Thank you. Thank you.
Any recross on those limited issues?
No, Your Honor.
All right, let's go ahead and take a 10-minute I'm sorry, before we do that. Thank you, sir. I assume we can go ahead and excuse the witness.
Yes, and thank you.
Thank you, sir. You are excused.
Or 79. Come to order.
Y'all be seated. All right. First things first, it did come to my attention during the break that Juror 380's image was actually broadcast. I have admonition again. Let's not let that happen. I usually allow one warning. Unfortunately, this is a significant issue, but I will allow warning. If in fact the court's order with regard to juror identity is violated, the court will have to sanction that individual. If it's the camera's gone. If it's anything else, the court will look at it as a matter of contempt. All right. Anything further, Mr. Donaldson?
I have two things. It'll be very brief. Juror 79 is here, but the only thing we'd be soliciting from her is the impact of the court's instruction on citizens' arrest. I understand that the court will not allow that testimony, and we'll just, we put it in, it is in our notice of intent, and I just, we'll release 79 if I'm correct in the court's ruling.
Well, the court's ruling is anything that has to do with the jury charge, because that would clearly be contemplated as violative of Rule 606. They would not be allowed to testify.
I understand. I just wanted to be sure about that, and that if I put her up, it would be futile in terms of, and so I don't want to take the court's time with that. The second is I do have some things of Juror 580 who announced to us that she would not be here. She's been subpoenaed. I don't know what to do about that. There is some material I'd like to ask her about she's been justifiably angry with me about even subpoenaing her, and I don't expect she would be a friendly witness, but now she's not a witness at all, or at least she's not here. I suppose we should sound for her. And if she's not here, then that's all we have, Your Honor. Subject to being able to submit the things we've talked about during the course of the hearing.
All right. The rule of sequestration had been invoked, so I understand Juror 580 is not available to the court.
That's my understanding. I haven't sounded for her.
Right. I normally don't sound in this courthouse, so I don't know how we would do that. Just sound the court.
In 79, we don't need her. She can go home because of her testimony would not be allowed. I do want to thank the court for its courtesy. Sometimes I'm not easy to put up with.
I won't worry about you being seated and not wearing yourself out, sir.
Well, I'm going through therapy. I've got legs that don't work, and so the rest of me is okay, except my shoulder. That didn't help. I also want to thank Ms. Dunikowski. She's been very tolerant of me. Were it not for the fact that she's an adversary, I think we'd be friends.
You can still be friends. All right, I understand we've sounded the corridor for 580. 580 is not available.
I have things to ask her that I believe are not violative of the court's rulings, but I don't know what to do about it. She's been irate. I've told her 2 or 3 different times, and we put her on an hour's notice and have called her, and she's been complaining that she's not coming.
Well, what I understand then from that is that you are not asking the court to enforce the subpoena.
I'm not, Your Honor. Listen, she thought she was done with this 3 years ago. If I were a juror and some lawyer that I didn't know came and said, come to court about it, I'd be irritated as well. So I understand her position. And I'm not asking the court to enforce the subpoena. I'm just announcing she's not here.
All right, so I understand 79 is not being called.
That's correct.
580 is not being called as unavailable.
Yeah.
As she is. Well, she's not unavailable. She's not here.
That's great.
I believe somebody had Mr. Goff still under subpoena.
I've released him from my subpoena.
Right. Any additional witness or evidence on the motion for new trial?
No, Your Honor. Just if the record be left open for submissions and the filings of the things that we've talked about, that I misinterpreted the court's order as to what we should do with certain filings. And I understood that the court wanted them, but that I was not to submit them to the clerk of court. And I'll submit them to the clerk of court, but it'll be a day or 2.
Okay. And then, Mr. Chappell, you're adopting the Travis McMichael motions. I know you're on the, I believe you are on the motion itself. And today's proceedings, adopting today's proceedings.
Yes, sir.
Anything further than from Greg McMichael?
We will rest on the brief regarding the other issues raised.
Mr. Zell.
Whatever you want me to do, I'm going to argue the effective issue or just written.
Let me figure out where we are with everybody. So, and Ms. Johnson, you're welcome to go ahead and sit back down. That's fine.
Thank you, Your Honor.
All right, just to make sure nothing from the state, correct?
The only thing from the state, Your Honor, is that with enumeration of error 5 from Travis and Greg McMichael was the issue with your order on excluding their use of force expert. When I went into the clerk's file on Odyssey, I could not find the order. However, I have a hard copy order in my file, and it looks like it was filed in open court. I spoke to the clerk today to ask if maybe, pilot error on my part, maybe I just could not find it, but the clerk is going to look for it. So I just wanted to make sure that a number of those written orders, and this was a November.
It was during trial. I thought we did a written order.
You did. And on the record, you say, tomorrow I'm going to put in these written orders, but they were stamped, filed in court, not filed through Odyssey. And so I couldn't find it in Odyssey, which is the electronic filing system. So the clerk and I are going to hopefully work on that because, of course, the order for the defendants needs to be a part of the record.
I couldn't find it as well, and if you could share it with me.
Oh, sure.
Well, let's do this. What we'll need is, if it is not in the record, I'm going to need a stipulation and then just a stipulation to the substitution of a file stamped copy into the record so that it exists in the record. But that's going to have to be all 3 defendants.
We can coordinate with that, I'm sure.
Because otherwise, the only thing that's in the record.
I'm sorry, Judge, but I downloaded the entire clerk's file from Odyssey, and I just pulled up a copy of this, the one you're looking for. So it would be, I didn't get a hard copy from the paper copy. Only thing I have to do, so I have one. So if this is what you're looking for, we can take a look.
Make sure.
And just see if that's what you're talking about.
That is it, November 23rd. So it appears Mr. Zell will be able to pull it down. I'm not sure where.
Which did you pull that in Mr. Bryan's case? Or
I think that was done, and that made the issue Odyssey's terrible, and each court is better for the other court is listening.
I refuse to be on the record.
Well, I'll go on the record. I'll go on the record with that.
I go into about 80 counties counties around the state, so I'll tell you.
We don't call it
Rodney, if
honesty
you'll
for
share
nothing.
that with us.
Well, I can't, so it's just, so they, a lot of times they do, and I have a problem with that. Chatham County, you have some sway in there, but obviously, they don't file everything in everyone's file case when it applies to everybody.
So what I understand, so just for the record then, in at least Mr. Bryan's case, there is a copy of my signed file stamped order on the denial of the use of force expert. That should exist in all three cases. And the court recognizes that. I'm trying to think for the record what else I would need to do to ensure that it is properly.
In order to, well, it's, there's some cases, when Chatham does the different indictment numbers.
This is one indictment.
So we say when I have that situation, I have the court do orders, we got the records from, but it's the same indictment. So it just needs to be something done with the clerk, and obviously.
I agree with Mr. Zell that it is a clerk issue, which I think we can coordinate with the clerk because the clerk's wonderful here.
Any objection to the court discussing with the clerk getting that order into all three cases?
No objection.
No objection, Your Honor, and there are a few other things that note to exist based on notes in my file, but that I was unable to find on the record. So
okay, well,
some of them are not relevant.
All right, let's one at a time. I'll speak with the clerk about ensuring that the use of force expert order is in all three cases.
It might help if I give Your Honor, Mr. Benegowski, the actual title that was downloaded in mine. If you want it, it just says order _ 80019CC7.
Rodney, if you just send us the copy.
I can send you a copy. You'll have that. I can email the chain. Okay. Because that's how they publish it.
Thank you, Judge.
Okay. All right. Everyone but Mr. Donaldson. So, Mr. Donaldson, I believe we have everything before the court. Before we talk about where we are with these transcripts, as far as where we go from here in timing. So I'll do it either way. Sometimes counsel want the transcript back and they want to be able to digest what's there and submit a post-hearing brief. Or we go through argument. We've got a number of parties, so I'm just wondering where everybody is. I will tell you that this case, we're already time-wise well down the road with it. All right, I'd like to keep this case moving along. So if we do wait for a transcript to come, the briefing schedule is going to be very quick after the transcript comes.
Thank you, Your Honor. I believe the court, the judge, I'm making the distinction, and parties have copies of everything, the transcripts of these interviews. And so I assume I don't need to send additional copies of those. I think everyone is, do you have copies of the transcript? I think
he's talking about the
Talking about the
this
transcript
one,
of
I'm
this
sorry.
hearing. And whether you wish to make a simple, let me simplify the question. Do you wish to present argument now, or do you wish
No.
to submit on the brief, or submit a brief?
Submit on brief, Your Honor.
Mr. Chappell,
I prefer it, right? Yes, sir.
Mr. Zepp.
Yeah, I will do whatever everybody wants to do. I didn't find arguing. I mean, I wouldn't take long, but I find doing a written brief after I get a transcript of it too. It's kind of like, Your Honor, I don't know which, I haven't appeared before Your Honor before, so I don't know. Judges have different preferences to all arguments or written briefs. And I know you like reading the trial transcript. I know you probably say it's up to you, Mr. Zell, but I do want to also accommodate.
I think if we are going to be waiting anyway, I would prefer then to put a single deadline on everybody and get everything before the court so there's no confusion with me on when matters are ripe. And the way I normally handle it with the state, if there's anything in those briefs that go beyond what has already been briefed by the state is going to be welcome to a response. So that's how I handle it normally. But relatively, normally it's like 10 days because a lot of this comes back to what's already been submitted. And I saw the state's responses are relatively comprehensive.
And the state has no need to file any supplemental briefs. So if Mr. Zell and the court wishes, we could do oral argument right now. It would be completed because everyone else, I think, is going to be resting on their briefs, and we would be done.
Well, we could do it separately. I would make Mr. Bryan's case ripe then before the court, then waiting on transcripts for the McMichaels. So, I mean, I'm happy to do it that way.
Oh, I misunderstood then. I thought the McMichaels were not filing additional briefs.
They said, both indicated they wanted to.
Oh, I'm sorry. Maybe I
I
misunderstood.
want to, excuse me. I want to see the transcript. I'll submit whatever. I'm not sure I need to submit an additional brief, but I'm kind of spent right now. I don't know that I can intelligently address the issue, and so.
Well, then it'd be a waiver of argument here and submit on the briefs.
Yes, Your Honor.
Mr. Chapman, same thing. All right, and then Mr. Zell, if you wish to argue, let's go ahead.
And just to clarify, it would just be regarding the 606B issue. That's the only testimony we have on the record.
That's the only thing that I can see that's out there.
I can take a few minutes. I mean, when I say brief, I mean, I generally brief. I don't want to belabor anything. And,
That's fine. Again, we have a number of defendants, so I want to make sure the pathway is clear. I'm happy to move the case along. So if you're prepared to move forward, I'm more than happy to hear argument, and that way we can close the motion for new trial, at least this phase of it, for Mr. Bryan. And I can get an order out.
We would not be closing for the McMichaels.
Correct.
Thank you, Your Honor.
I'll go ahead and Unless you want me, I'm just going to take a few minutes. If there's some questions about the law, then maybe I just send a letter brief or something like that. I just think it's necessary. Regardless.
Mr. Zell.
Thank you, Your Honor. I guess, well, my motion, I guess I'll open the conclusion. Makes it easy. All right, so I'll just start with the first issue, the statement. Yeah, I know, and most of Ms. Donikowski's brief was on the facts and the sufficiency evidence and things that I did not raise in my amended motion. And I know the state's theory is that, one, Mr. Goff did a lot of work on the case. I don't dispute that. And two, that generally an attorney's strategical decisions are not reviewable. I'm sorry.
You got to give a loud mic. So I don't know if there's any way to turn that mic off. That's
Oh,
a loud mic.
I'm so sorry, Your Honor.
Okay, we're all set.
Okay. And normally, I think Mr. Goff was clear that I think he clearly said it was strategy, and that was he wanted to do that, and we can't look at this in a hindsight perspective. But while I agree that he said it was strategy, that strategy has to be reasonable, and that's what the issue is. Was Mr. Goff's strategy reasonable? And that hence the couple of cases I did cite dealt with the issue of whether or not a strategy is reasonable. I don't think we really have this situation here. I mean, it's unusual for a defense attorney to allow their client to talk to the police in most situations. So here's what we have here, and why I thought the timeline was really important. And make sure. So the crime was February 23rd. And Mr. Goff probably talked to Mr. Bryan before he was hired, but not just, as he said, just a little bit, maybe just to touch on the case briefly. He was hired May 8th. 3 days later, according to Agent Seacrest, Mr. Goff says, we want to make a statement. Now, that is directly in contradiction from what Mr. Goff said. Agent Seacrest said he was pursued, whereas Mr. Goff said they asked Mr. Bryan first. Now, that's a credibility question. Your Honor's going to have to say it's in the transcript. I cited the page when I was making the question for the court, and
Seacrest trial testimony
in the Jackson Dino. There was a Jackson Dino hearing, and let me pull up because I did do just notes just specific to these straight issues. But yes, in Jackson Dino, he said that.
But I don't need to do this.
Yeah.
There wasn't.
Yeah, I was starting because that's been referenced a couple of times, and it's starting to occur to me. It may just.
There was, and then it was withdrawn, but it started. Let me pull up that transcript and see if I'm I mean, I have it I have notes, I have a date, I have a transcript, I have a motion hearing.
I have to go back into the record.
I have a date of May 13th, 2021, motions hearing, volume 1.
From May 21st of what?
May 13th is, let's see.
Of 21. We had a discrete number of motions hearings, and we can just go back into those transcripts. But if you have page, volume and page, we'll just based on that.
Here, let's see. So this is probably it right here. This is the because it's got the right date on it. You see that? On page 123, Agent Seacrest was called.
May of 21. Oh, May of 21. Was that the prelim?
It was May 13th, 2021. Let's see who the judge was. Let's see. Mr. Stonakowski, all the hoes.
In May of 21.
This was a motion hearing.
And Mr. Zell, what page are we on?
The hearing actually, and Judge Your Honor was presiding, so I don't think it was preliminary hearing. It starts, the testimony actually, in my notes, I have it started, his testimony was from page 123 to 165. Maybe we should do it by brief so you could have a chance to look at it. So I don't know. You already seen this, and it was almost at the very beginning, right?
And Your Honor, this was the very first motions hearing day that we had in May. So we had the 2 days in May, and then we had the 2 days in July. And I absolutely did not recall this because I know he withdrew his Jackson Deno motion, Mr. Goff did. So I did not recall Agent Seacrest testifying then, but it appears he did.
Okay. Yeah, I'd have to go back. I haven't looked at that transcript. Probably.
Maybe we should do it on a brief, and this might take a little bit longer than I thought. Then I don't know. There's more details.
Let's do that because I'd like to be able to
look at it and read it in hard copies. And so what I normally do is I'll just normally take pages from the transcript and attach them to make it easy for everybody to read it to as like a little. So I would attach that specific page and anything that I think is relevant, of course, and make it easy for everybody. So, okay, I will withdraw then my oral argument then.
Okay. So we'll do it on briefs.
Okay.
All right. So we'll do a briefing schedule. My normal course is to do 20 days after the transcript has been made available for briefs from the defense, and then 10 days after, well, it'll be 10 days after or 30 days for the state. So
20 days after the
20 days after the transcript's available. Does everybody understand that briefing schedule?
Yes, sir.
From the state?
Yes, Judge.
Yeah. All right. So then the last thing I need to tidy up is what the ultimate record is going to be with respect to these transcripts. The court, having heard from the witnesses and considering what is being proposed, I am not inclined to admit the transcripts for any evidentiary purpose. The question then becomes whether the court would permit those transcripts to be submitted for the record. And I have some concerns about that because I don't see them having any evidentiary value. And they are they contain information that ostensibly goes into jury deliberation and other matters, jury deliberation mainly being the concern for the court, because the basis for Rule 606 is that jury deliberations are sacrosanct. And what I do not want in this case is, and this is a unique case. This is a case that has taken on a life of its own over the last few years. This is a case where, depending on views, very different narratives have come out of it. And I have concerns that the irrelevant information is inflammatory. It is not in the interests of justice and would not be appropriate to be filed. Those are my concerns. Again, because it has no evidentiary basis, the court does not need it for the motion for new trial. What I understand, the McMichaels, Travis McMichael, mainly, and then I guess I'd hear from Mr. Chappell also on Greg McMichael, is that you simply wish to document the record to show on appeal what would have been available through these witnesses. Is that correct?
Yes, Your Honor. I would suggest or submit that there's a difference between 380 and the other two, because 380 testified, and there's some, and at the end he testified that what was in the transcript is correct. I don't believe, and I'll call through it, if there's anything about deliberations, I don't.
Actually, you know what? I'm not going to permit it. The more I think about it, if this matter goes up on appeal, and I'm reasonably convinced that it will, and the appellate courts look at my rulings on Rule 606 as made today and find that they were in error, then I guess I'd have to deal with that on a remand.
With that, I understand the court's ruling. I'm not sure what to do with the transcripts. I would submit that they should stay.
They're not part. No, they are not going to be made part of the record here because they're not. They do not contain any relevant material based on my rulings from earlier.
I understand, Your Honor. I guess I'll just have to figure it out later. At some point, if the court says it might have been, if the Supreme Court says it was relevant, then I think we'd have to come back down.
I think we all reconvene on the remand.
On remand, yes, Your Honor. And in the meantime, I don't know what to do with the transcripts, because you've always got to maintain a chain of custody. And
right now, it's not evidence that this. I mean, it's not in this court's purview, nor the clerk's.
I fully understand. What we'll do, if it has to come back down, we'll confer with Ms. Donikowski and make sure that what we submit is a true and accurate copy of what was here, that nobody's tampered with the transcript, and then we'll submit it.
If upon remand, we will figure out a way to address it.
There are lots of issues here that are kind of unique to me, in my experience. So,
sometimes we all just have to navigate things procedurally. But
we'll take custody of those transcripts, and I'll put them in my safe or something, and then we can address it if it's a remand.
And John, I'm assuming that your ruling also precludes the McMichaels from filing the truncated proffer sheets that were served upon the state and upon the court on this notice of intent to present evidence from jurors, but was not filed in the clerk's file because it has the same prejudicial, and it's even worse because it's cut up. It's excerpts. So
I do take issue with that, Your Honor. We submitted under seal with the court's permission. And we could ruling on that.
I think the issue on that is that was effectively the proffer. So that is what this court considered as part of the proffer. So it needs to come in. Again, the court has not found that to be relevant evidence, other than some of what may have
been used for impeachment purposes with 380. I'm going to allow it to be filed, but it is going to be filed under seal, the court finding that the court will make the necessary findings. I'm going to have to make some factual findings in a sealing order.
Thank you, Your Honor.
So what I'm going to do, go ahead and file the notice, submit the attachments to the court, and I will go ahead and file those attachments under seal.
But I don't need to file it then.
You need to file the notice.
I filed the notice. I didn't file the attachment.
Okay, then yeah, go ahead and submit the attachments to the court, and go ahead and put those under seal.
Thank you, Your Honor.
Y'all see this judge face? He is thinking very, very hard. We are literally at the end, and we're just going to talk about it. He is in contemplation because the transcripts that this gentleman has been trying to get in was related to that private investigator tricking the jurors into giving him a statement, and you seeing how the juror that was on the stand actually seemed a little confused about the information. I'm not biased, so I was like, uh-oh. So it was basically issues pertaining to when the juror actually was subjected to some of Ahmaud Arbery's protests. So it was seeming like it was being intertwined into one incident, but it seemed like it branched into two. So the judge didn't want to bring that information, one, because like you said, it's inflammatory, it's controversial, especially because the way it was obtained. But I don't know. So let's finish this watch. It is a few more minutes. We almost done. Thank you for being with me. I would listen. We got it in tonight. Look at the judge face. My baby red by this point. He really thinking like, damn, because if he didn't submit it, and they went on appeal, and in appeals court, they found that particular information could have played a role because it was already in these transcripts, even if they don't submit the actual transcripts, but because they talked about it on appeal, this is why they talked about certain things when trying to get this retrial. So on appeal, it could all be submitted. So that's why he was so adamant about trying to get this in. My baby right here got a red hot tamale face, but he did a great job. He did a great job as the judge. Look at him.
Any further business then from Travis McMichael?
No, Your Honor.
From Greg McMichael? No, Your Honor. From William Bryan?
No, Your Honor, I've already submitted the use of force order to his client and the rest of the attorney, so I'll try to have a copy.
From the state?
Nothing further from the state, Your Honor.
All right. Thank you, everybody. We are in recess.
Oh, I'm sorry. Okay, I was talking a little bit, but basically, I think that judge wanted to get it out of his court. Okay. You saw his face. The lawyer even said he gave apology to the judge and to the prosecutor because he said he know he could be annoying. Literally, it looked like he was gonna pass out through the whole thing, but he made it through the whole trial. And I have to give him his kudos. As a lawyer, he fought hard and he got those transcripts and he got them under seal. You see what I'm saying? So the judge probably like, whatever, at this point, I don't want to see him. He's like, I don't want this to be as complicated as it needs to be. I put it under seal. Y'all deal with it. So most likely this case is going to go on appeal to a higher court, okay, because they're not going to get a new trial. So I want to say thank you guys for being here with GracLevi tonight. It's been a long live. We made it through. I'm grateful that we are one of the channels that can do these long lives, and it's actually based on substance. I would like you guys definitely to participate, but I'm going to keep it spicy and keep y'all up to date, especially with the things that goes on in some of these cases and proceedings, because you can get kind of lost in the sauce or forget. So I just be, if I wasn't here, in the audience, I probably would have been just talking to the screen like, no, don't do that. Look at the judge. So I want to say thank you for being with Grace Levi tonight. Tomorrow we have a special guest for you. We're going to actually be doing adult table talk. We have our sister, Miss Nia, and we have some great conversation for you guys. So please join us tomorrow. Until then, we want you guys to stay sucker free, stay on point, and we'll see you tomorrow.
I could not be here breathing and be comfortable if I was really as bad as they was making. Nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. Live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Would you like to learn a brand new and innovative way to invest your extra money that has a low barrier to entry and low competition? What if I told you that it is a guaranteed method to get up to 18 to 20% return on your investment? Tax lien and deed purchasing is the only way to get into the real estate market through the back door. No credit and no loans needed. This method isn't commonly taught, and therefore the competition is very low, for now. Put together a 14-hour info-packed course which will teach you everything you'll need to know to get started. Learn at your own pace, step-by-step guided video and aids to start you on the TLC deed investment process. The course offers many learning tools for new investors, helping ensure you safely invest in tax liens and deeds. Contact us today and join the buyback team.